Chairman, we ready to go? Yeah. Good morning. Today, Tuesday, October 28th, 9 o'clock, and this is a committee meeting of the Motor Vehicle. This is a legal committee meeting of the Motor Vehicle Commission. Yes. I'm sorry.
I just need 1 minute. Sorry, I was about to tell you that.
Yeah.
And then
She just needs 1 minute, sorry.
Okay, today is Tuesday, October 28th at 9 a.m., and this is the legal committee meeting of the Motor Vehicle Commission. I am Commissioner Carl Kramer, Chairman of the Legal Committee. I would note for the record the following members of the Legal Committee are present: Chairman Roberts, Commissioner Norton, Commissioner Andrews, Commissioner Levy, and myself. Additionally, we are joined by our Executive Director, Denise Lawrence, and our Assistant Director, Jason Gilliam. Our legal staff, Erica Cable, Taylor Hinton, and also disciplinary counsel, and Sierra Shepard, who serves as our program attorney. Before I open the floor for discussion, I would like to make a motion that we omit item 69, number 202-503-6001, and number 202-503-6051, and move both of these for discussion by full committee. I believe council has some visual aids to share. I'll now open the floor for discussion from any member who would like to make comments on specific cases for our report.
May I ask just a general question? It seems that we're getting more dealerships that aren't responding and getting fines for not responding. Is that the impression of the rest of the legal commission? Did y'all notice that, or?
I did notice it.
And has there been a process change that's leading to people not responding, or are people just being ornery out there?
There's been no change in our process. From what I see, it seems to just kind of come in random waves. I've not seen any rhyme or reason to when it drops or when it, becomes more frequent.
Okay.
But I will say, I know I've said this before, but just reiterate that Taylor and I both work really hard to try to reach out to the dealership before we would ever suggest a fine.
Yeah, no, I
So
understand.
they've gotten a lot of attempts of communication from our side. But I wish that I knew a way to fix it or, prevent it. And I'm always we all are open to any suggestions you might have, being dealers yourself.
Well, and some of it, I think some stores may not be aware of the potential for an attention-getting fine. And I know we've got Tim Slattery in the audience. I don't know if that's a worthy topic for the TAA bulletin, to remind people of the importance of responding to this commission and the possible consequence.
I think that's a wonderful idea.
It's a good idea, but I'm afraid that a lot of the ones may not be members, so they may not get that memo, but still it's worth mentioning at TAA.
Yeah, I don't know if it'll cure the problem, but it'll clear my conscience.
That's right.
Is there a standard fine for not?
It's $1,000 for your first time.
And I noticed that, I just want to make sure we stay fair on that too. There were several some were fined and some were not for not answering.
Right, and anytime there's not a fine, there will be some serious mitigating factors that
Okay.
makes it a different situation, or they haven't received the certified mail and 30 days had passed.
Okay.
But I will say, since our rule has changed, any legal report, in the future, we won't have to wait those 30 days from certified mail being received, because we've changed our rule to state any communications from the Motor Vehicle Commission must be responded to. So we don't have to make that extra expense of paying for certified mail. And we can require you to, respond to email And I think a lot of dealerships, you know, probably rely more on the email these days than their mail.
Sure.
So I'm hoping the more we email, the better we'll get in touch with them, you know? But I think, like you said, having it in the TAA newsletter and possibly if we could do an email blast to everyone we have email addresses for, just reminding them that, you know, there's a pretty serious civil penalty if you don't respond.
And I also noticed a lot of cases were referred for investigation.
Yeah, I will say there was more than normal on
Yeah.
this report.
And that's got to be costly, and I'm only bringing it up for efficiency so that we don't run up cost for minor infractions.
Right, right. No, I think we take a lot of care in deciding whether or not to send something out for investigations. But if the commission were to notice cases that they think these are not a wise use of our resources, we're always open to that feedback.
Okay.
If you'd rather us hold back on certain, you know, if it's these allegations and you don't have a certain amount of proof, don't do an investigation. So
Yes.
that's just an example of feedback you can
That could be
provide.
one right there. That would be good. Is 123 on the ones that we're going to discuss later? I can't remember.
No.
Okay. Let me just ask about that one, 123.
Okay, 123, and
Uh-huh.
what was the question about it?
That's one that, now I just said that about investigations, but maybe that one does need an investigation. I don't know. You, tell me what your thinking was on that one.
Let me just refresh my
Possible title
memory.
washing. I mean, it should be referred for investigation if it was. I think you all recommended closing it.
Yeah, I think my thought here was, I had proof of a title that was clean.
Okay.
The actual copy, so to prove that the respondent didn't know that that was an accurate copy of it, you know, the most recent title. I think, from my experience, I don't know how we would prove that. If that's the copy of the title we have, that we had, you know, that they were given from the auction.
Sure.
So, but again, open to hearing from members who are in this, you know, in this business day to day, who may have more experience with auctions. Do you feel like there's a way that a dealer would have known that that wasn't an accurate title or a clean title, that it?
Well, it could have Carfaxed it, maybe. You know, Carfax may have given some insight. What do you think, Stan?
Possibly do. Carfax doesn't catch everything. It's a database that's just fed what it's fed. But, you know, you just have to follow the paper trail. And if the consumer is harmed, they have to follow the paper trail. And there's a trail back through the auctions. And that way there's recourse. But I agree with counsel. If the dealer was presented a good title, you know, it's really not on, in my opinion, it's not on him to bear responsibility. Now, there is a look back, but just only if the consumer's
I'm
filed.
pretty sure, I don't know that it was Carfax, but there was some sort of maybe an auto check,
Okay.
vehicle history report that the dealer did look at. Because I mentioned that, that there is the complainant was aware the vehicle's history showed a total loss. The dealer disclosed that with some sort of vehicle history report on top of there being a clean title.
Sure, okay. I'm satisfied with that. In case number 72, seems like that one may be a little over penalized on the procedural lapse. Maybe it would be 500, reduce it to instruction, or $500.
For the failing to respond?
Is that what we've been consistently doing? It is?
The $1,000?
Uh-huh.
Yes, that's,
Well,
ever
then
since
leave
we kind of raised some of the fines with our agreed
That's right.
citation schedule.
That's right.
It was
It
500
used to
for
be.
many
That's-
years.
That's, okay. I'm good with that.
And I will say, I think there's a couple on here, like you mentioned, where I did recommend 500 because I felt like there were some mitigating circumstances. I just didn't see that here.
Very good.
I'd
Okay.
also like to mention, we're talking about the mitigating circumstances. I appreciate you all paying attention to the vehicles that are sold as is. And I'm not sure if it's just a general rise in anxiety in the public or some such, but it does seem like I'm seeing more folks that intentionally select an as-is vehicle up front and then have an issue way on down the road. And I appreciate y'all looking at that, because if we can't sell vehicles as is, that'll make a real impact on the market. And if we're responsible for vehicles that we do sell as is in spite of the as is, I think that hurt consumers more than help consumers. So I appreciate y'all paying attention to that.
I agree. And for as long as I've worked for the commission, I will say that's probably the most frequent complaint we get outside of like delay in title and registration, is just either consumers not understanding what that means, or I think with just the rise of people on social media, making it their job to try to educate consumers about trying to get out of contracts when there's no legal reason. I think that just the rise in people believing what they hear on social media from influencers, I've seen a lot of that, trying to give you ways to get out of a contract that's, something like this. I've seen people, come up with some things that I know that they didn't think of. They probably got it from the internet.
So you may have encountered the sovereign citizens?
Yes. Just one of the many things that people come up with.
Could be a sign of the harder times, who knows? But anybody else?
Commissioner Norton, I have a few, if I may go over them. I have 4, actually. One of them's a nitpick. I've been doing this for a while, so I'll look at some of the detail. On number 7, unlicensed sales activity as an individual, and it was a letter of instruction. But my question on that would be, were these vehicles open titles, or were they titled in the individuals' names? I'm not sure who handled that one, but that's just something I nitpicked.
Let me double check before I.
And we do typically see unlicensed sales activities from individuals, roadside, stuff like that. But one of the things we got to be careful to make sure that if they are selling their own vehicles, they have to be titled in the consumer's name that's selling it. They can't be an open title.
I'm pulling up the titles.
Okay.
Pulling up the file to see if we have the titles.
And I'm in the next 2 are related, 33 and 39. So if you want to look at those.
So we don't have the titles. It was just the respondent telling the investigator. That's
Okay.
why it's a letter of instruction. And
I assume sometimes that happens,
Yeah.
but we need to make sure that, because that's a whole nother level of what they're not supposed to be doing as far as unlicensed activity. All right, so but they're within their rights to sell so many in a year, but they have to be their cars. They have to own those cars to sell them. It can't be an open title. It goes on a lot in the marketplace. That's part of the curb stoning issue. All right, thanks for that. And then also the next 2 are similar. They're unlicensed salespersons in the dealership. And 33 and 39 are both the same, unlicensed sales activity. And to me, it can happen to any dealership. And I don't know the details behind these 2 cases, but it's the penalties seem within the guidelines, but it seemed a little bit punitive.
And this is something that we discussed in depth, going back and forth of what we thought would be appropriate, and determined that we would put $10,000 on there and see what the commission felt.
Well, I mean, it caught my eye pretty quick, because we have multiple dealerships, and we work really hard to keep the license active and make sure they're current. And there's changeover in dealerships, there's administrative, if it's blatant, or there's something that you guys saw investigate that required an excessive penalty from being negligent, but if it's just an administrative oversight, I would recommend we look at this and not be so.
Yeah, and I'm totally open to that. This was just inconsistent with the scheduled
Yeah.
citations.
So, I mean,
I'm
But I'm
Also okay
open
with
to
that.
lowering it.
I'm also okay with that, with reduction.
Reduction, yeah. So, I mean, I would look, if there's anything egregious in either one of these cases, I'd like to hear it, but if not, I would move to discount these fines to a lesser amount.
And what amount are you guys thinking?
What guidelines, can you give me some guidelines on the range of, says 10,000, I'm assuming was the top end? Yeah. So-
Yeah, we did 10,000 for a similar matter, the previous legal report, and
We
so,
did.
yes. I think it might have been a little bit more cars, but 33 is for 65 vehicles that were sold, and 39 is,
I would at least cut it.
Well-
Can it be cut in half?
In 33, there was one salesperson.
39.
So that, I mean, I don't know if there's one salesperson in the dealership, if there's 20,
It appeared that it was
just one? Okay. And then administrative, and then 39, I'm not
It's
sure.
30, and then 39 is
Two salespeople?
2 salespeople and 39 vehicles.
Okay. I mean, Mr. Chairman, what would you recommend?
I would recommend just cutting it in half.
Yeah, I would be,
I think that's appropriate.
I would be okay with that. So I'd recommend we change that to 5,000 each instead of 10,000.
And going forward, is that what you guys would prefer to be the number we start with on this kind of
Well,
situations?
I think each situation warrants a different look
Yes.
based on, you know, administrative oversight or egregiousness or defiance. I mean, typically, if it's a, aha, oops, missed, I'm getting it done right now, you know, you just got to look at the
Yeah.
situation.
And for these going forward, we can just put discuss as a recommendation, so we can talk about them as a whole, if you guys prefer that, or we can continue putting the civil
it's-
penalties on there and
you-
discussing it.
We kind of need to ease into this rise because we've just gone up on our fines, and I don't, you know, sometimes they seem a little overwhelming at this point.
Yes.
But we do want to get there.
Can I get a mic? So I don't know, is it legally permissible for us to ask y'all, I know the intent of the fines is to change behavior, right? And I know the fine has a different impact depending on the situation and the organization. There are some folks that this would be a $5,000 or $10,000 fine would be a big attention getter. There's others that would be a cost of doing business, and they would chuckle and think about how much money they made over and above the fine and not worry about it. But are we legally able to try to tailor the punishment to fit the situation, or is that not a legal basis?
We do take into consideration the size of the dealership when considering these civil penalties that we recommend, and that is something within the statute that we are allowed to do.
So if we're allowed to do that, as we're trying to tailor these fines, is there a way for y'all to give us a basis for that in terms of the effectiveness of the fine based on the organization?
I will say in the past, Erica and I both take into consideration the size of the dealership, and we will look into how many vehicles they're selling a year. If it's a smaller dealership, we tend to recommend a smaller civil penalty.
But how do you all communicate that to us? Like with these two in particular, I have no idea. One of them sounds like a one-horse show.
If it was a smaller dealership where we got that information, we would typically include it within the summary or verbalize it when discussing it. I don't know if you have.
Yeah, but going forward, we can make sure
It's included.
to include that information. And just, this is just a place to start. Typically, unlicensed activity is $1,000 per act or per day. Just an idea, you could do, for a smaller dealership, $1,000 per expired salesperson. So like, one of these has two expired salesperson, you could do 2,000. And then on the other one, there's only one, and you could do 1,000. And that's, like I said, that's just a easy place to start. You can make it higher,
Or you could do 65 cars.
right, right. And that's kind of where we get to the 10,000 because we're capping it. Otherwise, it would be $65,000.
Right.
So there's a lot of different ways you can come at it, and we have a rule in here that gives us many factors we can consider.
So based on all that, as we're talking about these two particular fines and considering 10,000 versus 5,000, did you recommend 10,000 because you thought that was the magnitude it would take to get their attention? Or was that just based on capping it, given the fact that it could be much greater than 10 if we followed the transactional
Yeah,
guideline?
we discussed this, and there was differing opinions on what the appropriate amount would be on this, but we just decided that based on the amount of vehicles that were sold, and if we went by what they typically tell you to do with the 1,000 per violation, it would be a much higher number, and so we capped it at 10,000 based on previous decisions from the commission.
Okay. And do you feel, knowing the size of the organization, that 5,000 would be effective? Or do you feel like 5,000 would be just just paid by the bookkeeper and keep trucking?
I mean, if the commission feels that $5,000 is the appropriate amount for this kind of oversight, I mean, I think $5,000 would make an impact on any kind of dealership. It's something that they weren't paying before that they're now being required to pay.
I agree. And it's an embarrassment for a dealer to find this out. I mean, it's an easy fix, and it's not like they're trying to pay $35 to get a salesman's license. But anyway, yeah, I think 5,000 is an impact. But I understand what Commissioner's talking about, you know, the impact. Does it do it? And are we going to be objective or subjective about this? I think it goes with each case stand on its own. I don't think there's a formula to get there to calculate a fine.
Yeah, I think it's important to look at the case specifics for each matter and determine what's appropriate for the type of dealership as well as the type of action that happened. Another thing is if I send this consent order out and they come back and they explain they can't afford this, give any kind of reason, I would represent that and give you that information so you can redetermine if you think a lower civil penalty is appropriate.
I would remind everyone that no two cases are exactly alike. There's always
Yes.
a mitigating circumstance, and you look at the history, you look at the intent, you look at how long it was that they stayed unlicensed, and if it was a lot of them or if it was just one of them, there's a lot of things there. We just have to look at it. Okay?
And I have one more. I'll make it brief, but it's number 42. Complaint alleges respondent falsely advertising. And I've been passionate about this one for a long time. Advertising is important. And I've had friends and acquaintances been harmed by such acts of deceptive advertising, in my opinion. The difference between prices on dealer arranged financing, trade-ins, hard packs, very unfair. And I looked at this one. I don't know if there's anything inside this deal, but these acts were dodged with a letter of instruction. I found that to be a little bit concerning because I don't know the facts behind this, but everything in the bullet points, the 3 bullet points there, leads me to believe that actor's being very deceptive. And I wanted to bring that to the commission, or the legal review's attention, and see if anybody had similar feelings. I mean, I've spoken on this before.
I agree. That was one I had noted. I mean, it seems to me like they're showing rebates that everybody can't get, like, I don't know what, first responder rebate that not everybody would get. I assume it's the type of rebates they're showing. Then like you say, they're giving extra money for trade-ins, which not everybody will have a trade-in. And then the one that really struck me is when it sounded to me like they're offering more of a discount if you finance with them. That's definitely no.
Well, that's a deceptive from a state level, but from a federal level, that's violates truth in lending. So, I mean, it just struck me as odd that this would be just a. Can you elaborate why they were just issued a letter of instruction?
Sorry, we had discussed this as well, and just based on the history and their response, we were giving them the opportunity to have a letter of instruction at first, but I'm open if the commission thinks a civil penalty is appropriate.
Well, that's cool.
I'm sorry.
No, that's why, just a discussion on each one of these cases, like Chairman says, each one of them has mitigating circumstances. They're all different. And I mean, if this is something that's was received well from the investigator, corrected immediately, and with a response that was favorable to what we want, then I could understand that.
I do.
Taylor is being kind
Yeah.
to me and not throwing me under the bus, because I need to go back and look at my notes, but I'm the one that actually said, why are we doing a letter of instruction? And I don't remember what my thought process was. It probably was not rational at the time. So I'm going to go back and look at it and see if I can look for my notes that I made, but I think it's absolutely appropriate. given-
Looking at number 100, wasn't it a similar situation that we did find?
That is Erica's case. I don't know if you want to speak on what your thought process was with 100. And again, I'm open to a civil penalty. It was just based on the responsiveness and the no history.
If we do a civil penalty, what is your suggestion?
Do you want to talk on 100 first?
Well, I mean, just to give you, 100 is a complaint that I handled, and anytime that I see a violation of our advertising rule, which is like you're advertising a price that includes a rebate that doesn't apply to everybody. Or you're advertising a price that includes a discount if you finance with their lender. That doesn't apply to everybody. Or you advertise a price that includes a trade-in discount. Obviously, that doesn't apply to everybody. I don't ever see any kind of mitigating factor there. I think that that's incredibly deceptive. It's not fair to other dealers. I can only imagine the amount of money that they've made off of that kind of advertising, and then, how many people have come in and chose that dealership over another dealership. So I always recommend our standard $1,000 civil penalty per advertising violation. So here I found two in number 100, and I recommended a $2,000 civil penalty for that.
Well,
Or I'm sorry, it was just one. One of the issues was failure to respond, so.
Well, I mean, I might add a comment that, our mission statement says that we empower the consumer. This does not empower the consumer. It harms the consumer. And I see it all too often. It's way, I see it way more than we should. The baits and I mean, I've been doing this for 40 years. I understand the intent behind the dealer doing that, but it is deceptive and it needs to be dealt with, and we don't need to take it lightly.
I think a $1,000 civil penalty is appropriate if that's what
Okay.
the commission feels.
I'm good with that.
And obviously, I'd like to recommend a follow-up to make sure that they're compliant.
Absolutely.
I can include in the consent order that they need to, if you guys vote on that, let us know within 30 days that they've updated their
Okay.
website.
Absolutely.
Well, in number 42 especially, it seems like they thought they could explain their way out of it by their disclaimer. It really doesn't matter. They're disclaiming, yeah, that,
Well, it's deceptive and it violates truth in lending.
I agree with the fine.
So I've updated that to $1,000 and for them to update the commission within 30 days that their website has been updated.
That's good.
And if we make sure to monitor their disclosures and other things going forward, just to see if they're actually repentant or if they're just didn't like getting caught.
Can you elaborate on what your expectations are with the monitoring?
well, the
I
three
would say
bullet
just-
points that you hit, you can't disclaim your way out of that.
Right. Do you just mean like we just can check one time in 30
Yeah.
days to make sure that they've
That's exactly what
updated?
I mean.
Okay, yes.
Yeah,
We're just making sure
we
that,
can do that.
yeah.
Yeah,
And I
yeah, no,
agree.
I don't mean put them on double secret probation. I mean,
Yeah,
just go ahead.
Yes, no, I'll include that in their consent order.
right. And we don't ever allow a disclaimer to negate the deceptiveness of, a violation of price advertising rules. So they can, because I've seen a lot of dealerships try to do that. And at least for my cases, and I'm pretty sure for Taylor's, that doesn't ever fix it. So not only do they need to fix the violation in the price advertising, but we require them to fix their disclaimer too.
Okay. I don't have anything else.
Okay. So I'd entertain a motion to adopt the legal report as amended by the legal committee.
So moved.
Second.
Denise?
I apologize, Commissioner Norton has made a motion to adopt I'm sorry,
No, he did. I
the
seconded
legal
it.
report as amended, seconded by Chairman Roberts. Commissioner Levy?
Aye.
Votes aye. Commissioner Andrews?
Aye.
Votes aye. Commissioner Norton?
Aye.
Votes aye. Commissioner Kramer?
Aye.
Votes aye. And Chairman Roberts?
Aye.
Votes aye. You have adopted the legal report.
Me?
Yes.
Okay. We need to adjourn. Okay. Carl, you want to call for an adjourn?
Second.
All those,
in favor?
Aye. Okay. Today is Monday, March 17th at 10, let's see, nope, at 9:30. And this is the rulemaking hearing commission meeting of the Tennessee Motor Vehicle Commission. Denise, would you call the roll on, whoa. Yes, I do. Everybody else, come up. Yeah. I thought you knew automatically you were coming up.
To be invited.
You are.
When do you get all polite and stuff?
Come on up, Jim. How are you, buddy? I like your case.
All right, so it's a retrospective rule review.
Yep, gotta go do that little housekeeping. Is there anybody else that's out there wandering?
And just a quick note, Commissioner Elam had texted me and said that she was stuck in traffic. Oh, okay, I didn't even see you. And Commissioner Rydell and Morgan, I haven't heard from, yay, Rydell is here.
Good.
I'm sure Morgan is on his way. It must be really bad out there. Thank you.
I'm gonna go ahead and introduce one of our newest members of the commission. He was seated last week, Jim Karras from Memphis.
Appreciate it.
Glad to have him with us.
Yeah, welcome. Thank you.
So,
Honored to be with you.
yeah. And anyway, I'm gonna go back and say it again. Today is Monday, March 17th at 9:32 a.m., and this is the rulemaking hearing commission meeting of the Tennessee Motor Vehicle Commission. Denise, would you call the roll?
Yes, Mr. Chairman. Commissioner Andrews
Present?
is present. Commissioner Copenhaver
Present.
is present. Commissioner Galvin
Present.
is present. Commissioner Karras
Present.
is present. Commissioner Kramer is present. Commissioner Levy
Present.
is present. Commissioner Morgan is on his way. Commissioner Norton
Present.
is present. Commissioner Rydell
Present.
present. And Commissioner West
Present.
is present. Commissioner Yarborough is present. And Chairman Roberts.
I'm here.
Mr. Chairman, you have a quorum.
Just to make a quick clarification, I think you may have said the date wrong at the start. Today's October 28th. I think you may have been looking at minutes or something, because I think you said March 17th.
You're exactly right. You are exactly right. I'm reading my notes.
Okay, okay. Just making sure.
Denise, what do we got here?
Because that's when. we
That's the
adopted-
rulemaking, that's when it was adopted.
That's correct.
Okay.
So this is the public hearing.
Okay. All right. So that date was the date it was adopted. And so, meeting notice, are you going to read that, Denise?
Yes, sir. This meeting's date, time, and location have been noticed on the Tennessee Motor Vehicle Commission's website, included as part of this year's meeting calendar since December 3rd, 2024. Additionally, the agenda for this month's meeting has been posted on the Tennessee Motor Vehicle Commission's website since October 21st. It's also been noticed on the tn.gov website.
Okay. I'm ready. I remind any members of the public in attendance who wish to make a comment on an item listed on the posted agenda will need to sign in on the public comment sign-in sheet at the front of the room. Or is that in the rear of the room? In the back of the room. That was misstated too. Additionally, we are joined by our Executive Director, Denise Lawrence, Jason Gillum, Assistant Director, and our legal staff, Erica Smith, Taylor Hilton, and Sierra Shepard, who will serve as our program attorney. Erica, what is your new last name?
It's Cable.
Cable, okay. I'm going to correct that also. I will now turn over our program to turn over the meeting to our program attorney, Sierra Shepard, and who will take us through the proposed changes to our rules.
Good morning. The rulemaking hearing is called to order. My name is Sierra Shepard. I serve as Associate General Counsel in the Department of Commerce and Insurance Division of Regulatory Boards, and I represent the Tennessee Motor Vehicle Commission. Would the agency representatives who are present introduce themselves for the record?
Denise?
I'm so sorry. What did you say?
Can the agency representatives who are present introduce themselves for the record?
Denise Lawrence, Executive Director. Is that what I need to do?
And then just,
And then,
Ian Levy, Commissioner.
Charles West, Commissioner.
John Rydell, Commissioner. Tim Copenhaver, Commissioner.
Nelson Andrews, Commissioner.
Chairman John Roberts.
Jim Karras, Commissioner. Jim Galvin, Commissioner.
Stan Norton, Commissioner.
Terry Yarbrough, Commissioner.
Carl Kramer, Commissioner.
today is Tuesday, October 28th, 2025. This rulemaking hearing is taking place pursuant to TCA Section 4-5-204 in Conference Room 1A, David Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee, and is available by electronic means via Microsoft Teams, which can be located on the program's website at www.tn.gov/commerce/regbboards/MVC/meetings.html. On this page, the link for access to this rulemaking hearing via Microsoft Teams can be found in the chart located in the middle of the web page in the row with the date 10/28/2025 in the location column under the words Davy Crockett Tower, Room 1A, 500 James Robertson Parkway, Nashville, Tennessee, 37243, and the link is labeled Connect. The purpose of this rulemaking hearing is to solicit comments on amendments to the rules and regulations of the Tennessee Motor Vehicle Commission. The proposed rules make several amendments as a result of the retrospective rule review completed by the department as required by the General Assembly's enactment of TCA Section 4-5-213. First, the motor vehicle or recreational vehicle show fee will be deleted and 2 license fees will increase. Specifically, the following license fees will increase. 1, application for endorsement of change of employer of a motor vehicle salesperson by an employer, and 2, each name change including additional line make. Both fees were mistakenly excluded from a rules package that went into effect September 15th, I believe, that included fee increases to the same rule. Next, a dealer who is relocating will be required to submit a new application and notify the commission within 30 days of its anticipated relocation date. Requirements previously governing motor vehicle shows will be removed to more accurately depict existing shows and displays. And finally, 3 new rules will be added to ensure that automotive dismantlers and recyclers are held to the same standards as outlined in the general rules. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of the Secretary of State. Notice is given to the public for comment, and the rules are forwarded to the Attorney General's office for review of legality. If approved, the proposed rules are filed with the Secretary of State, which is responsible for publication in the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days. The effective date of the rules will be the end of that 90 days. Please listen carefully. Those members of the public wishing to speak and appearing in person should place their name on the sign-in sheet, which is located at the table behind me at the back of the room. Those members of the public wishing to speak and appearing via Microsoft Teams should put their name in the chat box. Oral comments will only be accepted by those who have written their name on the sign-in sheet or typed their name in the chat box. Is there anyone else that desires to offer oral comments but has not written their name on the sign-in sheet or typed their name in the chat box? Seeing that there are none, for those attending this hearing in person, I will call your attention to the table located directly behind me. On this table, you will find red-line copies of the rule amendments addressed in today's rulemaking hearing. For those attending on Microsoft Teams, you will find a link in the chat box to the red-line copies of the rule amendments for today's rulemaking hearing. The notice of rulemaking hearing includes the entire text of the proposed rules and was published on the Tennessee Administrative Register website on August 8th, 2025. Ms. Lawrence, what additional notice was given to the affected individuals or groups?
first, information for the time and location of today's hearing was placed on the program's website. Additionally, an e-notify was sent to all licensees who've signed up for the program system on August 11th, 2025.
I will now summarize the substance of the proposed rules into the record. Rule 0960-01-14, license fees, subparagraph 1F, is amended by deleting the language $35 and substituting the language $50. Rule 0960-01-14, license fees, subparagraph 1K, is amended by deleting the language $400 and substituting the language $600. Rule 0960-01-14, 8.17 motor vehicle shows. The title of the rule is amended by adding the words "and displays," so that as amended, it reads motor vehicle shows and displays. Additionally, this rule is amended by deleting subparagraph 2 through 6. It is amended by renumbering subparagraph 7 as subparagraph 2 and deleting the word show and substituting that word for the word display. Finally, the rule is amended by renumbering subparagraph 8 as subparagraph 3 and deleting the phrase "without obtaining a motor vehicle show permit." Rule 0960-01-.21, motor vehicle or recreational vehicle dealer facilities, is amended by adding a new subparagraph 6, so that as amended, subparagraph 6 will state the following: a dealer must submit a new application and notify the commission in writing within 30 days of the anticipated change of location of their facility. Rule 0960-02-.11, civil penalties, is added as a new rule. This rule states that in a lawful proceeding, the commission may assess a civil penalty for each separate violation of a statute, rule, or order. This applies to individuals or entities required to be licensed, registered, or certified who is otherwise subject to regulation by the commission. It also provides factors that the commission may consider in determining the amount of a civil penalty. Rule 0960-02.12, compliance with state and federal laws and regulations, is added as a new rule. It states that all the commission's licensees must comply with all applicable Tennessee law, federal law, and regulations. Rule 0960-02-13, mail from commission, is added as a new rule. It states that generally a licensed individual or entity or any individual or entity required to be licensed must respond in writing to any communication from the commission requesting a response within 30 days of mailing that communication to the last address furnished to the commission by the licensee. As the agency hears public comment on the proposed rules, I, as moderator, reserve the right to limit such comments if they become repetitive. Before I take public comments, I will read comments that I have received via email prior to this hearing. Today, I have not received any public comments via email pertaining to the rules for discussion at today's rulemaking hearing. Ms. Lawrence, was there any written comments received by the commission office regarding these rules?
No, we did not receive any public comments.
Are there any public comments from those present at today's meeting, either in person or via Microsoft Teams?
No.
I have observed no comments. Lastly, there are several measures I will need to adopt by motion roll call vote as required by TCA Section 4-5-222. First, I will need a motion to adopt the hearing rules language.
I apologize. We were having a little hand motions thing going on there. I think Chairman Roberts wants to interrupt for a quick second.
Welcome.
Did you hear anything I said? She can't hear you. Oh, she can't hear me. Tricia, I'm sorry, I didn't hit the button.
No, you're looking
You gotta turn it back around.
You're looking at a picture.
Yeah.
It's not her, really.
It's really not her?
You look at her right there if you want to.
Oh, there she is. All right. Tricia. Okay, welcome. This is a little wonky this morning because none of this was planned until this morning. But anyway, thank you for joining us. I know you got appointed last week, I believe it is. So we look forward to having you serve with us.
Thank you. I'm looking forward to it.
Okay. Now,
If I may interrupt, Commissioner Elam has entered the meeting. Thank you.
And welcome. First, I will need a motion to adopt the hearing rules language.
So moved.
Second.
The motion to adopt the rules as amended, made by Commissioner West and seconded by, made by Norton and seconded by West. Commissioner Levy?
Aye.
Votes aye. Commissioner West?
Aye.
Votes aye. Commissioner Elam?
Aye.
Votes aye. Commissioner Rydell?
aye.
Votes aye. Commissioner Young? You can vote, Commissioner Young, if you'd like. Yes. Okay, we're going. Commissioner Copenhaver?
Aye.
Votes aye. Commissioner Andrews?
Aye.
Votes aye. Commissioner Karras?
Aye.
Votes aye, Commissioner Yarborough.
Aye.
Votes aye, Commissioner Galvin.
Aye.
Votes aye, Commissioner Norton.
Aye.
Votes aye, Commissioner Kramer.
Aye.
Votes aye, and Chairman Roberts.
Aye.
You have adopted the rules.
Next,
Okay.
I will,
Go ahead.
oh, sorry. Oh, no, go ahead.
No.
Okay. Sorry, next I will read the regulatory flexibility addendum pursuant to TCA sections 4-5-401 through 4-5-404. Prior to initiating the rulemaking process, all agencies shall conduct a review of whether a proposed rule or rule affects small businesses. The commission currently licenses 3,360 new auto dealers, used auto dealers, and recreational vehicle dealers across the state of Tennessee. Of that amount, an estimated 60% of these licensees represent small businesses, which are those selling less than 300 vehicles annually. An estimated 40% represent larger dealerships, which includes new auto dealers and used auto dealer licensees. Over 900 licenses are issued to auctions, manufacturers, and distributors, vehicle representatives, and dismantlers and recyclers, all of whom represent larger business interests. Though the 60% of the commission's licensees considered small businesses would be affected by the increase in licensure fees, that dollar increase is minimal, with the larger businesses bearing the greater monetary increases. The following amounts represent the money that the licensees will pay on top of what they already pay for their license renewals. The cost is the compliance of that raised fee. For each application for endorsement of change of employer of a motor vehicle salesperson by an employer, the biennial cost of compliance will be $50 or an increase of $15 per licensee. For each name change, including additional line make, the biennial cost of compliance will be $600 or an increase of $200 per licensee. There is no need to acquire new skills or additional record keeping. Small businesses will be affected because they will also have to pay the increased fee. However, these fees were set with small businesses in mind, and the raised compliance cost is as minimal as possible to accommodate those businesses. Consumers are unlikely to see any impact. There are no less burdensome or less costly alternatives to these rules. The raised fees are necessary for the commission to maintain self-sufficiency. Exceptions cannot be made for small businesses without severely affecting public safety. There are no known federal counterparts to the commission to compare the commission's proposed rule. After reviewing existing licensing fees of surrounding states and adjusting those costs to reflect biennial renewal, our proposed fee increases appear to be commensurate with the licensure costs across the Southeast. Finally, the raised fees are necessary for the commission to maintain self-sufficiency. Exceptions cannot be made for small businesses without sacrificing self-sufficiency and severely affecting public safety. I will now need a motion to adopt the regulatory flexibility addendum.
So moved.
Second, Commissioner Galvin.
Motion to adopt the regulatory flexibility addendum made by Commissioner Norton and seconded by Commissioner Galvin. Commissioner Levy?
Aye.
Votes aye, Commissioner West.
Aye.
Votes aye, Commissioner Elam.
Aye.
Votes aye, Commissioner Rydell.
Aye.
Votes aye, Commissioner Morgan.
Aye.
Votes aye, Commissioner Young is abstaining. Commissioner Copenhaver.
Aye.
Votes aye, Commissioner Andrews.
Aye.
Votes aye, Commissioner Karras. Votes aye, Commissioner Yarborough.
Aye.
Votes aye, Commissioner Galvin.
Aye.
Votes aye, Commissioner Norton.
Aye.
Votes aye, Commissioner Kramer.
Aye.
Votes aye, and Chairman Roberts.
Aye.
Votes aye. You have adopted the regulatory flexibility addendum.
I will now read the impact on local government statement. Pursuant to TCA Section 4-5-228, the Tennessee Motor Vehicle Commission foresees no impact on any local governments. I will now need a motion to adopt the impact on local government statement.
So moved.
The motion to adopt the impact on local government statement made by Commissioner Norton, seconded by Commissioner Galvin.
Galvin. So moved.
Commissioner Levy.
Aye.
Votes aye, Commissioner West.
Aye.
Votes aye, Commissioner Elam.
Aye.
Votes aye, Commissioner Rydell.
Aye.
Votes aye, Commissioner Morgan.
Aye.
Votes aye, Commissioner Young is abstaining. Commissioner Copenhaver.
Aye.
Votes aye, Commissioner Andrews.
Aye.
Votes aye, Commissioner Karras.
Aye.
Votes aye, Commissioner Yarborough.
Aye.
Votes aye, Commissioner Galvin.
Aye.
Votes aye, Commissioner Norton.
Aye.
Votes aye, Commissioner Kramer.
Aye.
Votes aye, and Chairman Roberts.
Aye.
Votes aye. You have adopted the local government impact statement.
I will now read the answers to the questions required by the Joint Government Operations Committee. All agencies upon filing a rule must also submit the following pursuant to TCA Section 4-5-226I1. Question A asks for a brief summary of the rule and a description of all relevant changes in previous regulations effectuated by such rule. The proposed rules make several amendments as a result of the retrospective rule review completed by the department as required by the General Assembly's enactment of TCA Section 4-5-213. First, the motor vehicle or recreational vehicle show fee will be deleted and 2 license fees will increase. Specifically, the application for endorsement of change of employer of a motor vehicle salesperson by an employer will increase, and each name change, including additional line make, will increase. Both fees were mistakenly excluded from the fee rules package, which included fee increases for the same rule. Next, a dealer who is relocating will be required to submit a new application and notify the commission within 30 days of its anticipated relocation date. Requirements previously governing motor vehicle shows will be removed to more accurately depict existing shows and displays. And finally, 3 new rules will be added to ensure that automotive dismantlers and recyclers are held to the same standards as outlined in the general rules. Question B asks for a citation to and brief description of any federal law or regulation or any state law or regulation mandating promulgation of such rule or establishing guidelines relevant thereto. There are no known federal or state laws or regulations mandating the promulgation of these amendments. Question C asks for identification of persons, organizations, corporations, or governmental entities most directly affected by this rule, and whether those persons, organizations, corporations, or governmental entities urge adoption or rejection of this rule. The rule amendments affects current and future licensees as well as applicants. Current and future licensees and applicants who do not want to pay additional money may oppose the rules. However, industry members who understand the board's need to be self-sufficient will be in favor of these rules. Question D asks for identification of any opinions of the Attorney General and reporter or any judicial ruling that directly relates to the rule or the necessity to promulgate the rule. There are no known opinions of the Attorney General and reporter or any judicial ruling that directly relate to the rule or the necessity to promulgate the rule. Question E asks for an estimate of the probable increase or decrease in state and local government revenues and expenditures, if any, resulting from the promulgation of this rule, and assumptions and reasoning upon which the estimate is based. An agency shall not state that the fiscal impact is minimal if the fiscal impact is more than 2% of the agency's annual budget or $500,000, whichever is less. The additional revenue the commission projects from the promulgation of this rule for fiscal year 26 and fiscal year 27 is $637,000 and $937,000 respectively. That also includes the fee increases that we did last month. Questions F, G, and H request identifying information of agency representatives that will explain the rule at the committee hearing and the contact information of these agency representatives. I, Sierra Shepherd, am listed, and Denise Lawrence is listed as executive director. And question I asks for any additional information relevant to the rule proposed for continuation that the committee requests, and there is no known additional information. I will now need a motion to adopt the additional information for the Joint Government Operations Committee.
So moved. Second.
The motion to adopt the additional information provided by the Government Operations Info made by Commissioner Norton, seconded by Commissioner Karras. Commissioner Levy?
Aye.
Votes aye. Commissioner West?
Aye.
Votes aye. Commissioner Elam?
Aye.
Votes aye. Commissioner Rydell?
Aye.
Votes aye. Commissioner Morgan?
Aye.
Commissioner Young abstains. Commissioner Copenhaver?
Aye.
Votes aye. Commissioner Andrews? Votes aye. Commissioner Karras?
Aye.
Votes aye. Commissioner Yarborough?
Aye.
Votes aye. Commissioner Galvin?
Aye.
Votes aye. Commissioner Norton?
Aye.
Votes aye. Commissioner Kramer?
Aye.
Votes aye. And Chairman Roberts? Votes aye. You have adopted the government operations information.
So this concludes the rulemaking hearing. Following this hearing, the rules will be submitted to the Governor's Office for final review and then submitted to the Attorney General's Office for review and approval. Once the Attorney General's signature is obtained, the rules are filed with the Secretary of State and generally become effective 90 days from the date of filing after receiving a positive recommendation from the Joint Government Operations Committee. Again, that concludes the hearing, and thank you for being here today.
Thank you, and appreciate that, Sierra. Good report and good information. We're going to take a recess just for like 5-7 minutes to try to get started as close to 10 as we can. So some of us just need a break. So, all right. Let's go ahead and be gathering in, getting started. Anybody else that needs to be brought in? It's outside? Okay. All right, this is the regular quarterly meeting of the Tennessee Motor Vehicle Commission, and I call this meeting to order. And if Executive Denise Lawrence will call our roll.
Yes, sir. Commissioner Andrews
Present?
is present. Commissioner Copenhaver
Present.
is present. Commissioner Elam is present. Commissioner Evans
Here.
is present. Commissioner Galvin
Present.
is present. Commissioner Young is
Present.
present. Commissioner Karras
Present.
is present. Commissioner Kramer
Here.
is present. Commissioner Levy is present. Commissioner Morgan
Present.
is present. Commissioner Norton
Here.
is present. Commissioner Rydell
Present.
is present. Commissioner West is present. Commissioner Yarborough
Present.
is present, and Chairman Roberts.
Present.
Mr. Chairman, you have a quorum.
Thank you. Notice of public comment to be held at the end of the meeting. So if you haven't signed in, go ahead and do so. The meeting notice has been,
I can read it again if you like, just for the record.
yes.
This meeting's date, time, and location have been noticed on the Tennessee Motor Vehicle Commission website, included as part of this year's meeting calendar since December 3rd, 2024. Additionally, the agenda for this month's meeting has been posted on the Tennessee Motor Vehicle Commission's website since October 21st, 2025. This meeting has also been noticed on the tn.gov website.
The adoption of the agenda, didn't we have changes?
Yes, sir, I think you had a motion to make to amend the agenda.
Okay, we already did.
No, we haven't done it yet. You
Oh,
need
we
to
haven't
make
done
that
it yet.
motion.
That's what I was asking.
Commissioner
Motion.
Norton, Commissioner Norton, motion to adopt.
Okay, we have a motion first by the chairman to amend
Amend.
the agenda. And the amendment, I believe, if you don't mind me stating, Mr. Chairman, is just that our program counsel, Sierra Shepherd, after the legal case report and the legislative updates, will be presenting You Are My Sunshine, what is it called? Open.
You Are My Sunshine. Sorry, it's the You Are My Sunshine presentation. It's about the Open Meetings Act law. We're just gonna go over that. Usually they do it, I believe, every 2 years, so it's just time to do that.
And Sarah, I thought that was a joke when I read it. But I take it serious, okay?
Okay, motion to adopt the agenda as amended by Commissioner Norton, seconded by Commissioner Galvin.
Any further discussion? Would you call the roll?
Commissioner Levy?
Aye.
Votes aye. Commissioner West?
Aye.
Votes aye. Commissioner Elam? Votes aye. Commissioner Rydell?
Aye.
Votes aye. Commissioner Morgan?
Aye.
Votes aye. Commissioner Young?
Aye.
Votes aye. Commissioner Copenhaver?
Aye.
Votes aye. Commissioner Andrews?
Aye.
Votes aye. Commissioner Karras?
Aye.
Votes aye. Commissioner Yarborough?
Aye.
Votes aye. Commissioner Galvin?
Aye.
Votes aye. Commissioner Norton?
Aye.
Votes aye. Commissioner Kramer?
Aye.
Votes aye. Commissioner Evans?
Aye.
Votes aye. And Chairman Roberts.
Aye.
You have adopted the agenda as amended.
Okay, everyone was mailed the minutes to the last meeting dated July 22nd of 2025. What is your pleasure on the minutes?
Make a motion, Commissioner Norton, to approve the minutes.
Second, Commissioner Galvin.
Any further discussion on the minutes? Executive Director Lawrence, would you call the roll for the approval of the minutes?
The motion is to adopt the minutes from the July 22nd quarterly meeting made by Commissioner Norton and seconded by Commissioner Galvin. Commissioner Levy?
Aye.
Votes aye. Commissioner West? Abstains. Commissioner Elam? Oh, my goodness. Commissioner Rydell?
Aye.
Votes aye. Commissioner Morgan?
Aye.
Votes aye. Commissioner Young abstains. Commissioner Copenhaver?
Aye.
Votes aye. Commissioner Andrews?
Aye.
Votes aye. Commissioner Karras?
Aye.
Votes aye. Commissioner Yarborough?
Aye.
Votes aye. Commissioner Galvin?
Aye.
Votes aye. Commissioner Norton?
Aye.
Votes aye. Commissioner Kramer?
Aye.
Votes aye. Commissioner Evans?
Aye.
Votes aye. And Chairman Roberts.
Aye.
You have adopted the minutes.
Okay. Anything I'm forgetting at this point, Denise, because we've changed everything up so
I know.
much? If not, we'll go.
I think we're ready to go into our appeals.
Salesman, okay, we'll go into the appeals. Salesperson and dealer appeals. We first have Cameron Thomas. Is he here? Would you come on down to the mic here? And Miss Sierra, you're going to give us some information on this?
Sure, so this is Cameron Thomas. He was convicted of aggravated assault. The latest date of release, probation, or parole is January 16th of 2025, so the commission has discretion to deny until January 16th of 2030.
Yeah, Sarah, can you talk a little bit closer to your mic?
Yeah,
It's
sorry.
a little bit quiet, but we did hear your introduction. Anything else you need to tell us about the background?
No, so this is just for aggravated, not just, but this is for aggravated assault, and you guys have discretion to deny until January of 2030.
Okay, is there any other information you
No.
can share or need to?
No, the applicant can give you any more additional
okay.
information. That's all the information I had, though.
Okay. Mr. Thomas, would you tell us about your, what did I say? Mr. Thomas? Yeah. Would you elaborate on your trouble you were in?
Yes, so I had made a little minor mistake hanging out with the wrong crowd of people. I was fresh out of high school whenever I had picked that charge up. Since then, I actually been going through a lot of expungement programs and different second chance programs just to turn my life around. I really was trying to put that life behind me, and so I wanted to change my career path and become a car salesman, and so that's really why I'm here.
And when was this charge?
2018.
2018?
Yes, sir.
I'll open it up now to the other commission members to ask questions and see what you want to ask Mr. Thomas.
Mr. Thomas, Commissioner, were you here the last meeting?
Yes, sir.
Okay, I thought so. Will you refresh us on, tell us about what your charge was related to? I think drugs were involved and assault was
Yes.
involved?
Yes, so back then I was in a little bit of drugs, and so it was just basically me trying to just find myself for real, and I had to take the time to sit down through that trials and tribulations of my life and actually get my thoughts together and get my life together, because I didn't just do it for myself, but I also have 2 kids that I have custody of, and I had to just change for them to show them better too.
Did you say you just got custody of your children?
I've been having custody of my children for about 5 to 6 years now.
It was my understanding the last time you were here, you didn't have a dealership that you were employed by. Is that correct?
Correct.
And are you employed by a dealership now?
Yes, sir.
Okay. So based on my memory serves me, he had a good story. We all believed him. But you just didn't have anywhere we could approve a license. Is that correct, staff? Okay. I mean, that's all I've got.
Did you bring anybody with you?
Yes, sir, I did. I have the owner of the dealership, Chili.
Would you come up, please, sir? And state your name and your role in Mr. Thomas's employment.
Hi, my name is Alex Hopper. I'm the owner of Hopper Auto Sales. First and foremost, I want to say good morning to everybody. I'm absolutely ecstatic because I love coming back and seeing a bunch of people that I know. It makes me feel good to have this young man beside me. Just to give a little bit more of a backstory on this young man, he might be a little bit shy, especially if it's choice of words. But if you see this man smile, it'll light up a room, okay? Everybody's made mistakes. I've been up here before vouching for young men that I have mentored in the past to be able to have bigger and better futures. Just a little bit past story about myself for the people that don't know about me. 8 years ago, I was in the same boat, did some bad decisions when I was a young kid, not really having a lot of guidance. I was able to come up here and get my sales license after having a convicted felony myself, and now I run a dealership. It absolutely opened doors for me me, and one thing that I've always been able to do is try to give back to the community and help young men like myself that I see striving potential. Just a little bit more story about his background. I know assault is a very big charge. We're all young and dumb. Everybody has a past, and there's no point of hurting somebody from their past that's trying to better their future. This young man was doing some things that he wasn't supposed to do. Through the aggravated assault, he was actually defending himself, but through the court system, he had to take a plea in order to be able to move on from his mistakes. Since then, he has been an outstanding community person. He has 2 kids that he takes care of every day. And he actually called me. He called me a week before he was supposed to come here. He was actually supposed to be employed by Kia. He was working there for about 3 months. The week before he was supposed to come up here to get his sales license, of course, they let him go. Being the young man that he is and being an overachiever, apparently he came up here by himself, still thinking he can get a sales license without representation. Now, one thing that I absolutely love about this kid, he shows up to work on time, amazing attitude, always ready to go. And also, I love the thing about young people who are going through hard situations is their sacrifices. A lot of people don't like to talk about the sacrifice you have to take in order to move and be a better person. This young man has seen multiple men, especially young men that I brought up here to do this with, be able to sell cars, flourish in their lives, be able to, take their kids out to eat or be able to have a vacation. This young man has definitely taken a real blow these past couple of weeks, especially money-wise, time-wise, mental health-wise, physical-wise, and emotion. One thing about us as men, we want to feel like we're, what's the word I want to say? We want to feel like we can provide, right? And I've seen this young man sacrifice to get to this moment today. Okay, this young man has a bright future. I think he's going to definitely be a great salesman. But on top of that, I think he's going to become a great person. My goal as somebody who's a leader of my dealership is I want to strive for people to always become better. This young man has shown tenacity. He's been able to show leadership. He's been able to sacrifice himself. This young man goes from cleaning toilets to anything that I ask of this young man. And he's bent down to the bare bones trying to make sure that he's on the right path of becoming a successful young man. Now, it's not just about the money. It's about the feeling, knowing that you have the opportunity to be able to be from your past. Okay, this young man is bright. I can't talk enough about this young man. I absolutely love him. The whole entire staff loves him. When customers come into the door, he's having amazing conversations with them. And, I get it, especially as a young man that's been through his prior situation, that all we need is a chance. This young man wants to be able to strive, be able to provide for his family, be able to fall in love with the job that he absolutely loves, and be able to flourish in it. And I think with your guys' help, the opportunity for him to become a successful young man, a great entrepreneur, and hopefully be able to strive to get bigger and better things in the future really lays in your guys' hands. Again, I've been up here before. I have vouched for young men to be able to better themselves and get an opportunity to have a sales license. And pretty much every person that I feel like I took a chance on, you guys have took a chance on, has flourished. They are in better situations for their family. They're in better homes. They're in better cars. They can finally pay their cell phone bill. They're able to provide for their family and feel the sense of self-need. I appreciate you guys so much for at least giving us the opportunity. I love this guy's tenacity, and I know if you guys got a chance to talk to him a little bit more, you'll definitely fall in love with him as much as I have. So,
Commissioner Galvin, Mr. Harper, for one thing, I don't think he's shy. It takes a lot of courage for a gentleman like him to come last meeting by himself, not employed by a dealer. The dealer wouldn't come at all, and then they get rid of him. That takes a lot. It's a lot of character. I would have approved him last meeting, but we couldn't because he didn't work for anything.
Yes,
but as of today, I would highly recommend, and we all grant Mr. Thomas his sales license.
Is that a motion?
That is
It's
a
a motion.
I agree.
Commissioner Norton, I'll second. It's Commissioner Norton, I'll second, and I'll say, Mr. Harper, thank you for your leadership. We need more people like you in the industry, and we wish you the best luck if it passes. I think it will. But I'll
Thank you.
second.
Thank you, Mr. Norton.
Any further discussion? Executive Director Lawrence, will you call the roll on this?
The motion made by Commissioner Galvin and seconded by Commissioner Norton is to grant licensure to Mr. Thomas. Commissioner Levy? Votes aye. Commissioner West? Votes aye. Commissioner Elam? Votes aye. Commissioner Rydell? Votes aye. Commissioner Morgan? Votes aye. Commissioner Young? Or you
Aye.
abstain? Thank you. Commissioner Copenhaver? Votes aye. Commissioner Andrews? Votes aye. Commissioner Karas?
Aye.
Votes aye. Commissioner Yarborough? Votes aye. Commissioner Galvin?
Aye.
Votes aye. Commissioner Norton?
Aye.
Votes aye. Commissioner Kramer?
Aye.
Votes aye. Commissioner Evans? Votes aye. And Chairman Roberts?
Aye.
Votes aye. Your license will be granted today, and you should receive an electronic copy. We'll probably send that to Mr. Hopper's attention. And then you'll get the original in the mail in about 14 days. Thank you. Good luck.
Thank you for appearing.
Thank you, guys. We appreciate your time.
Okay. Yeah. I don't know. Knoxville. Okay, Mr. Struble, you want to give us some background on Mr. Struble?
Sure. He was convicted of delivery of meth and 2 counts of theft in the first degree. The latest date of release and parole for the meth charge is October 10th of 2027. And for the theft charges, it's April 10th of 2024. So you have discretion to deny based on the theft charge until April of 2029, and based on the meth charge until October of 2032.
Okay. Would you come on up to the mic, please? Mr. Struble, just elaborate on what you've been into in your life and where you lead up to today.
At 18 years old, I got into the car business, and drugs were kind of a dominant thing in that time. I started using drugs, and it affected me in a pretty complicated way. So early on, I got in a lot of trouble, even had a prison sentence when I was 19. I got out, met my wife of 30 years almost today, had 6 children, moved to the Medford area in the car business, and stayed sober for a total of 15 years after a couple of relapses. Had some problems with my hip, manipulated the doctors to prescribe me lots of pain pills, and when I realized or was made aware by my wife how much of the pain pills I was using, I tried to get off of them, and I fell back into my addiction from 15 years prior. I got pulled over after a multi-jurisdictional investigation for methamphetamine delivery, May 1st of 2018. I continued to use for about 9 months following that, and I got sober, pulled my life back together following a program, U-Turn for Christ, in Grants Pass, Oregon, which I went into 9/11 of 20 on my birthday. I lost my wife. None of my children would talk to me. I pretty much sacrificed everything in my life for my addiction. After the program, I was still fighting the delivery charge. The theft charge was secondary to it because of the size of the delivery charge. I moved around and worked and took care of my family and put my life back together as best I could. November 22nd of 2022, I had the delivery charge beat on a technicality, but the theft charge, which interestingly I wasn't guilty of, was still pending, and I wouldn't have been able to go back to work, and I couldn't afford to feed my kids anymore. So I pled to both charges and started back to work in the car business the following day. I had a good reputation in Medford working for Lithia Motors for many years, and I'm very talented at it. I've stayed clean and sober since 9/11 of 20. All of my kids are here in Tennessee with me. all of my kids and all of my grandkids, which I have a lot of each. I bought a home, went to work for Jeff Root at the Ford dealership 4 months ago, and it's the greatest place I've ever been. I love it.
Okay. Any questions for Mr. Struble at this point?
I have a question, Commissioner Norton. Are you actively current in a recovery program now, and do you?
I am not. I attend church and I work. I don't know who's been in the car business, but I work and I go home to my family. That is my recovery, and on Sundays and in the evenings and mornings, I spend some time with God, and that's kept me clean now for over 5 years. It kept me clean for 15 prior to that.
That's all I got.
Okay. Anything else for him, for Mr. Struble? Who did you bring with you?
Mr. Root, the managing partner of the Ford dealership that I work for.
Would he like to come up and address us? If you would, state your name and what your relation is to Mr. Struble.
Yes, sir. Thank you. Good morning, Commission. Thank you for taking the time to speak with us. You have to excuse me. I've stuttered ever since I was a kid, and sometimes you would never know, but occasionally in situations like this, it certainly comes out. I had the chance to meet David March of this year, a prior employee of mine. Actually, I'm sorry. Jeffrey Root. I'm the managing partner at Ford Lincoln in Cookeville. Been there 12 and a half years. Have a great store, great team, great community that I'm actively a part of. I'm the chairman of the Chamber of Commerce. I'm on several boards. I'm actively involved in what's happening in that town. Absolutely love it. But I had a chance to actually meet David March of this year. A prior employee of mine called me and said, "Hey, Jeff, I've got a guy that I want you to meet. I think you're going to absolutely love him. But he wants to be a sales manager," which I'm a promote from within. I have a culture of cultivating people to be as successful as they can possibly be. Got to spent at least an hour getting to know him, and of course at that time he was upfront and honest about what had happened in his life. When that unction to function kind of hits you, I said, well, this didn't go as I expected it to. I'm going to hire you. And since he started, he's been a blessing on me. He's been a blessing on our team. My salespeople absolutely love him, even though they hated him initially because he was a manager coming aboard onto a team that I didn't ever operate that way. In the 12 and a half years I've been at that store, I've never come here. I've been asked to hire salespeople and other employees that would put me in this situation, and I've never felt the desire or that I wanted to stick my neck out, and I had to stick my neck out to hire him. I mean, it took a call to my business partner to say, I'm responsible. And again, I'm grateful that I did. I'm grateful that he's on staff, and I'm asking that you guys give him a second chance. He moved all the way here from Oregon. Obviously, I think all of us know that we live in the best state in the country. Great place to do business, and again, be as successful as you want to be. So that's the request I make, is that you guys give him a second chance, and I wholeheartedly believe that you won't regret it. Thank you.
Thank you. Before the commission asks you any questions relating to this, to Mr. Struble. Mr. Struble, did you make restitution for your?
So for the theft charge that I pled to, I had to pay $6,000.
And you made restitution?
Yes, sir.
Okay, good. Any other questions?
Yeah, Commissioner Norton, first, Mr. Root, I admire you for your support for Mr. Struble. Mr. Struble, I admire you for your being clean since 2020. However, we have to ask the questions to get to the decision. So my question would be, Mr. Root, do you have a random drug testing policy. And the reason I ask that, I know it's tough, it's hard, and our business is very emotional, and it tests everybody to their last strength. So my question is, do you have a policy to follow up on that?
We do not know. No, sir.
I am currently on probation. I was required to transfer it here, and they do have a drug testing policy prior to travel. They did put me on the lowest level of probation after the interview. I've only drug tested twice, but it is a policy that I submit to that upon request.
Okay. That's all I have.
Any other questions from commissioners?
I have a question for legal. So it says here that the applicant was ordered to pay $6,000 in restitution. However, council is unsure whether that was paid. How do you guys verify that? Other than him telling us when we ask him.
I could probably log into the state of Oregon and go to the restitution due area, and it would show a zero balance. It was a requirement of me leaving the state of Oregon that I had no restitution and that I prepaid the Oregon fees to be here, plus whatever was required once I came here. They won't let you leave without it.
So we would only have be able to go by what they state, and that's why I put in there, I was unsure whether or not it has been paid, but I did note that there was restitution that was ordered to be paid as part of his settlement.
Okay, thank
The
you.
information would have to come from the applicant.
Got it, thank you.
And we can also ask them to provide that documentation as well, like proof that they've made the payment.
Mainly, I just was not sure. I know in your system, sometimes applicants have to go in and click stuff all the way through to verify that they've done certain steps, and I just wasn't sure if that was part of this process as well.
I don't think that's part of this process.
Okay, got it, thank you.
So the Commissioner Norton, so if we made a motion to approve or grant him his salesman's license, and based on the fact he paid that, we could grant those based on the fact he did pay that, correct?
I'm sorry?
Never asked that before.
I don't think you can make a conditional granting of licensure.
Well, I'd like to make a motion, we grant him his salesman's license.
I second. Commissioner Yarborough, I second.
Any further discussion? Executive Director Lawrence, will you call the roll for the vote?
I have just gotten a promotion.
Yeah.
The motion is to grant licensure made by Commissioner Norton and seconded by Commissioner Yarborough. Commissioner Levy?
Aye.
That's aye. Commissioner West?
Aye.
That's aye. Commissioner Elam?
Aye.
That's aye. Commissioner Rydell?
Aye.
That's aye. Commissioner Morgan?
Aye.
That's aye. Commissioner Young?
Aye.
That's aye. Commissioner Copenhaver?
Aye.
That's aye. Commissioner Andrews?
Aye.
That's aye. Commissioner Karras?
Aye.
That's aye. Commissioner Yarborough?
Aye.
That's aye. Commissioner Galvin?
Aye.
That's aye. Commissioner Norton?
Aye.
That's aye. Commissioner Kramer?
Aye.
That's aye. Commissioner Evans? That's aye. And Chairman Roberts?
Aye.
Votes aye. Mr. Struble, we will grant your licensure. You should receive, or Mr. Root should receive an electronic copy in the mail today, in his email, and then we will forward you the hard copy of it in about 14 days. Congratulations.
Thank you, gentlemen.
Thank you for your time.
Okay. Okay, next on the list, Terry Kopp. Come on down, please, sir.
So Mr. Kopp was convicted of unlawful manufacture, deliver, possession with intent to deliver cocaine. His latest date of release was November 18th of 2025. So you have discretion to deny until November 18th of 2030.
Okay, Mr. Kopp, would you talk to us about your background and where you were, where you are now?
Yes, sir. Thank you all for taking the time to listen to me today. That was happening in Wyoming. It was a charge of possession of cocaine with intent. The way they write it up in Wyoming serves as she said. The incident of the night, it was seeing friends I haven't seen in quite some time. Of course, went out, having some drinks. We all threw in money for the enjoyment of the night. Hours later, the cocaine was passed out between who all threw in, unbeknownst to me at this point. We all enjoyed our night. The next morning on the way to breakfast, I did get pulled over for not coming to a complete stop at a stoplight. The responsibilities of the whole night do lie on me. I had my portion in my pocket, and I don't know why I didn't throw it away many times throughout the whole night. It's still in my pocket. I take responsibility for all of it. Didn't get breakfast that morning, and I ended up getting a charge of 48 years. My charge was resentenced in 2018 because it was a 16. I did get early release. I get put on probation. I did get an early release on probation. This drug counseling and stuff, we did go in and I went through all the process of doing testing, seeing counselors, and they deemed that I didn't need any counseling. Upon release and probation, we did do drug testing, never had an ill test. Everything's been positive. And I did do another counseling after probation to show that if I needed counseling, I would go forward with that and take care of my responsibilities. It proved that I didn't need counseling, and I submitted that to the council. Now I'm in Chattanooga, in Wyoming, being as it's a small state, small cities, and big family name, everyone was still doing the same things. No one's changed. Life just stayed the same. Their choices were the same, mine weren't. I had an opportunity to come out to Tennessee, work with Jason, start up his new dealership. It's been going swimmingly so far. I've been putting in the effort, doing everything that needed to be done to get things moving forward, and it couldn't have been the best decision I've ever made. I love it here in Chattanooga. I got roots here. Well, I'm in Nashville now, but Chattanooga. But I got roots. Everything's settled. Everything feels like it's supposed to be. But those are my responsibilities. Never had a past prior to that in drugs or anything. Just rambunctious night, and it is what it is, and those are my responsibilities.
Okay, any questions for Mr. Kopp?
Commissioner Norton, have you, other than this crime, or this, where you're charged in 2016, have you have any other charges or been arrested for anything else?
I had, when I moved up here, I have a criminal trespassing, which I submitted also. I parked my moving vehicle in a parking lot across the street from my house, and ended up there having problems with neighbors working on the cars and leaving cars. So when I went and got my truck again, I parked on the other part of the parking lot, thinking it was I don't know what I was thinking, it was a different part of it, and it so happened to be the same part. I did go to court over it, and it was dismissed. I presented that paperwork to the court, or to the council also.
Okay. Curiosity on what quantity of cocaine did you have when you were pulled over?
2 grams, 3 baggies, and they used that as distribution because it is in 3 separate baggies, though it was only one quantity, one purchase.
Did you pay for that cocaine, or did?
Yes.
How did that? I don't know anything about it.
Sure, no worries. How it all came about was us friends were at the Wonder Bar having drinks, haven't seen each other in a few years, and my buddy came up, slapped us down on the table, and said, "Everyone, throw in, for a good night." So we all pulled out money and threw it in our pockets. An hour later, he came back and just distributed, cocaine that he'd gotten. I kept mine in my pocket because that wasn't me. So it still ended up in my pocket the next morning, went to breakfast, and got pulled over for not coming to a complete stop when I was trying to get into the parking lot and find me a spot.
Is it that much?
The size of your thumbnail.
Like a thumbnail,
Yeah,
okay.
it's
All
a
right.
very small amount, but it is a very important.
My wife's a pharmacist, and I can't tell you what a gram is, or milliliter, or any of that.
It's maybe a little smaller than your thumbnail.
Okay. Did you, any more questions for him before we bring up who did you bring with you?
Jason Holm.
Okay. Would you come up and address us? Tell us your name for the record and what your relation is to Mr. Kopp.
Yes, my name is Jason Holmes. I'm the owner of Car Depot in Chattanooga. I hired Terry. I opened a car dealership in Cleveland, Tennessee for about 1.5 years. We grew, so I was looking for a bigger lot and found one in Chattanooga. So during that transition, I'm like, we're growing, so we need to grow our staff as well. So Terry was the first person that I interviewed while I was still at the old lot for the upcoming position at the new lot. He kind of intrigued me with his story. I mean, he's a really nice guy. It's kind of my take from him, you know, from the interview. Really nice guy, well-spoken. Just from being in the car business so long, he just seemed like he would do well with customers. So made the transition, moved to Chattanooga. There were some things, or actually before I moved to Chattanooga, there was some things that needed done to the new lot. Terry stepped up, you know, before he even started, you know, so I paid him a little bit before then. He stepped up and said, hey, man, anything that you need done, you know, to help get this new place open, I'm available, I'm ready. He was there 9 o'clock a.m., you know, every morning helping me paint, get things ready for this lot. So I personally grew to build a relationship with Terry while we're there. You know, the day that we opened, you know, until now, which has been about 2 months since we've been at the new location, customers love him. I mean, he's got so many 5-star reviews from customers. You know, I can't really ask for a better employee. I've had some not so good employees in the past, and comparable to Terry, I mean, he's a great asset to the company. And, you know, I'm really proud to have him on the staff. Hearing his story, what happened in the past. Also being a man not perfect, you know, I've made some bad decisions in the past. The difference in us, I just didn't get caught. So by the grace of God, you know, just left that life behind me. So his story kind of intrigues me, and I can see, you know, a change. I didn't know Terry back then, obviously during the charge, but I know Terry now. And, you know, I put my position on the line for him.
Okay, questions from the commissioners?
I make a motion that we grant the salesman's license.
Second, Commissioner Andrews.
Any further discussion? Executive Director Lawrence, would you please call the roll on this vote?
The motion is to grant licensure by Commissioner Norton, seconded by Commissioner Andrews. Commissioner Levy? Aye. Votes aye. Commissioner West? Aye. Votes aye. Commissioner Elam? Aye. Votes aye. Commissioner Rydell? Aye. Votes aye. Commissioner Morgan? Aye. Votes aye. Commissioner Young?
Aye.
Votes aye. Commissioner Copenhaver?
Aye.
Votes aye. Commissioner Andrews?
Aye.
Votes aye. Commissioner Karras?
Aye.
Votes aye. Commissioner Yarborough? Aye. Votes aye. Commissioner Galvin?
Aye.
Votes aye. Commissioner Norton?
Aye.
Votes aye. Commissioner Kramer?
Aye.
Votes aye. Commissioner Evans?
Aye.
Votes aye. And Chairman Roberts?
Aye.
Votes aye. You have voted to grant licensure to Mr. Cobb. Mr. Cobb, we will send a copy of the license electronically to your sponsor, and then you'll receive a copy of it, a hard copy in the mail in the next 14 days. Congratulations.
Thank you, Commissioners and Chairman.
Okay, thank you. That concludes our appeals. And now, if Executive Director Lawrence will give her report.
I will be happy to do so. We have, the applications for new dealers has gone down just a little bit from our last meeting. I think we had 62 this meeting and 75 for the last one. All in all, our licensees numbers remain fairly steady. It's remarkable how close they are in number from quarter to quarter. I also wanted to let you know that we have collected a total revenue of $101,100 from the collection of late annual sales reports. Our metrics are still incredibly good, even though we are still short-staffed, but everybody really, really pitches in to make it work. And I'll never be able to tell everyone how much I appreciate their discipline and devotion to the Motor Vehicle Commission. I think our licensing numbers really lift the rest of the division up because we license in such a short amount of time. So we're really pretty proud of that. Also, you know, as you all see, our attorneys work tirelessly to get all of the information before you for our legal reports. They have gotten longer. We may want to talk about adding a meeting or doing something different. I want to make sure that you all are comfortable with the time that we have to review all of the facts for every case, and because I know that you're all very thoughtful about how you rule on everything, and you take an awful lot of time to look at them, and that makes us feel good. I think that we're doing our licensees a good service. I wanted to let you all know that our fee increase did go into effect on September 15th. Chairman and I, along with Assistant Commissioner Witcher, appeared before the Government Operations Committee this month on October 14th to defend our audit report. The audit report came out and there were no findings. We had one observation, and that was just about appointments over which we really have no control. But all in all, we had a really, really good report. It was painstaking. It took a long time because they looked at 5 years because they haven't looked at it before now. Also, as a result of our fee increases, if you will, there's an NPS, net position statement at the back of your packet. I think it's the final thing in your packet. And those are the last numbers that we have. I mean, we expected to end this year really in the red, and we came in at $25,000 in the red, which is phenomenal. We have really cut back on investigations, on everything that we could possibly do, and I mean, it shows. Also, the tireless work of our attorneys netted between our last meeting and this meeting, $112,000 in fines. That's a lot for us. We don't usually get that much of a yield. Jason Taylor and I were privileged to go to the NAMBIC conference in San Diego in September. We got a lot of good information, a lot of good presentations. There was a really good one on advertising that maybe we can talk about sometime soon if I can get that information from them. As you may remember, I'm on their board, and they are really striving to become more and more relevant. And I've already gotten commitments from some of you to attend the conference in, I believe it's going to be in Providence, Rhode Island next year. I think they could really benefit from some of your input. I know many of you are involved nationally, and I think that would be very beneficial. There's going to be another dealer training that we're participating in with TNIDA and the Department of Revenue on the 25th of November, and I believe they have their annual conference upcoming, and I think they probably would like to say something about that at the end. And that's really all I have to add. We did include the disciplinary action report, which represents the combined collection of the $112,000, if you guys want to look at that. And
Denise, one thing, if you don't mind me adding.
Sure.
At the government ops, that they did grant us a
Yeah,
4-year extension.
I left out the
So we
most
get to
important
live
part.
and breathe another 4
Yes.
years.
Yes, I left out the most important part. They have extended the commission until 2030. So
Yeah.
we will be around at least until then. We wanted 6 years like we got the last time, but.
We just didn't ask for it.
Yeah, it's typical.
They would have given it to us.
Yeah, it's typical for them to do 4 years,
Yeah.
and next time we're gonna ask for it. So,
Yeah.
Anyway, that's all I have. And I would suggest that we do a voice vote to adopt the director's report.
Okay.
If and when you're ready.
Got a motion?
So moved.
Motion to adopt the director's report made by Commissioner Andrews and seconded by Commissioner Norton.
Any further discussion? All those in favor say aye.
Aye.
Okay. No? Do we have any noes? Okay. All right.
Okay.
Legal. Let's go to legal. Who wants to clean that up for us?
Okay, thank you, Chairman. In the legal committee review, we discussed moving number 69, which includes 2 complaints against the same franchise dealer, to this full meeting so I could show you the mailer, like the game Monopoly type piece, because it's very hard to describe something like that in a summary. And I think it would be actually more fair to everybody, even the dealer, for you guys to see it. So I've redacted everything to keep this anonymous, but I wanted to show you the actual mailer that was received by the complainants. So I'm gonna go ahead.
So we're going to do this, Erica, and then we will decide on it to go in with the legal report.
Correct.
Okay.
And I might add, if you all could refer to number 69, that's actually on your iPads, because we revised the summary a little bit, and I think it would be more accurate for you to follow along from your iPads.
Okay, we're working on making it larger for you, so just bear with us.
And while we're waiting on that, I'll just add that Erica, Taylor, Jason, and I are going to be working on some guidance, some advertising guidance that we can put on the website. It always seems to be the issue that everyone gets stumped on, and I'm not sure how much more direction we can provide, but we're really gonna put our heads together and see if we can come up with something that will assist our dealers in ensuring they're compliant with our rules and regs.
Well, while we're waiting on this to be enlarged, I'll just kind of summarize the complaint again for you. Basically, we have 2 complainants that received this mailer, and it's like a scratch-off Monopoly type game. And the concern that staff had, and I think the consumers had as well, is the game itself seems to kind of contradict itself a few times, where just by looking at it, it might look like you won a certain prize, but then you also have to, well, I'll just use the words it uses itself. So to play, simply lift tabs on card. If you have a matching set, you win. So it could be as simple as that, but it's not. In addition to that, the winners have to call a phone number and match a confirmation code, which is also on the mailer. And then they have to go to the dealership itself and match their confirmation code to a prize board. And if they happen to be in the running for one of the top prize, they have to go to the dealership and get another scratch off and scratch that off to see if they've won the top prize. So it's really, another reason I wanted to show it to you is because I think, you have a lot of discretion in our advertising rules to, if you find advertising of vehicles to be fraudulent, misleading, or deceptive, then it's a violation. So really, we're just asking you to decide if something like this, if you feel like it's deceptive or not. So now you can see it for yourself, and I'm just gonna kind of go over what I just said again, but point to where I'm referring to. So this is the front of the mailer that the consumer would receive. And if you can see, right here is where they would, let me just make sure, yeah. Okay, so right here in the kind of center right is where they would scratch off, I'm sorry, center left, they would scratch off their mailer. And then over to the right is where the explanation of the game lies. So like I said, the first instruction is to play, simply lift tabs on card. If you have a matching set, you win. And then you have your asterisks. So it's not as simple as that, although it says it is. Then, underneath that, winners have to call a phone number. And I redacted that to keep it anonymous, but there's a phone number there that they would call. And then you have to match the confirmation code here. I guess you'd give it to the person that you would call, and the people answering the phone is the advertising agency, the third party that the dealership hired.
But not the dealership.
No. And so then you also, underneath there, you proceed to the dealership, which I redacted, during the event to claim your prize. So the complaint, one of the complainants stated that they called, because they were skeptical of this game in the first place. So they called the number. They were told they won the Amazon gift card. And they were still skeptical. I think they asked a couple times just to clarify, are you sure before I drive here? Are you sure that I won this? Yes. So then they went and looked at Google reviews and testimonials about this game and saw that a lot of people felt like it was a scam, or they felt like they were misled, or they drove to the dealership to find they did not win the prize they thought they did.
What would they give them as the reason they didn't when they got there?
I don't know. I don't know. I just know that it seems like some people don't understand.
Can we see the asterisks?
Yeah, I'm going to take you down. I just really quick before I do that. So when he decided to call back a second time because he felt like, yeah, I've been told I won this prize, but it doesn't seem like that I really did, and I'm going to drive there possibly for no reason. So he called again the number, and after talking about the reviews, he saw and saying, look, I don't want to drive there if you're not sure that I won this. And the person that answered the phone eventually said, well, you may not have won it. So that is kind of the essence of the complaint. And like I said, there's other reviews and testimonials that say the same kind of thing. So now I'm just going to go down.
But before you leave that part, you
Sure.
mentioned that when you call the number, you get the advertising agency, not the dealership.
Right.
Yes.
In the written part, it also seems to indicate when you go to the dealership, it says something about 3 visiting salespeople, including someone who's a leader of a visiting salesperson. Is that the advertising agency as well?
I don't believe so. I honestly, I just know that they're licensed salespeople. I think they work at the dealership.
No.
But I'm not sure.
Commissioner Yarbrough, they do not.
Okay.
I mean, this whole thing's been going around since 19.
Yeah, I've seen a lot of these complaints.
It's a ploy tactic. It's almost a pressure for dealerships to use this because they probably have pressure on the manufacturer, for one thing. So they need their number.
Oh, I'll turn mine off.
But I've seen this. I mean, I'll be the first one to admit, our dealership used to do this a long, long time ago. I stopped it. I hate it. I know all about this. They hire outside salespeople. When they hire outside salespeople, for one, do they contact you guys to make sure they got a license in here during the sale? They probably do not. The outside agency, you know, they're from another state. Is it regulated from the state of Tennessee that we use here? No. I mean, all these small disclosures are horrible. Customers do get confused, you know. But the problem is it keeps going on and on and on, and we don't do anything about it. I mean, I see it. I'm going to be honest with you. I got one the other day in the mail, and I'm not going to tell you the
I've gotten
dealership.
one too.
You know, is it my duty to call that dealer and say, hey, I'm on the Motor Vehicle Commission, you better watch out because we're going after you? My question is, are we going after these people? You know, I listened to all this. I listened to what the legal review said this morning about a few of the dock fees and the processing fee being too high. Are we going after those dealers? I know a couple dealers right now that have high dock fees. We've always talked about it. But this kind of thing right here, we need to target it. We need to drill these dealers, and we need to have major fines on these things because this is absolutely false.
Well, that's another reason I wanted to show it to you, because seeing it and trying to describe it are two very different things. But not only, I think, are a lot of dealers using this kind of game, but it seems, I mean, they sent out 100,000 of these. And it brought in around 1,000 people to their dealership. That is affecting a lot of consumers. Of course, we only got these 2 complaints about this. But I agree with you. I think that, it's kind of time for the commission to decide how they feel about this. And again, you have discretion under the advertising rule. If you find something to be misleading or deceptive, that's all you need to find for it to be a violation. And I want us to be consistent in how we handle these going forward, one way or another. I'm trying to present this as objectively as I can, but based on what I've seen, it seems like people get really confused, and looking at it, I think it's got too many different directions.
Can we see the asterisk?
Yes, yeah. So I'll go
Let
down.
me ask this. I know basically why the dealers are doing it. They're probably covered up in inventory, and they're trying to cut their inventory overnight by a big amount. I can't believe that only 1,000 inquired about it, because if you send out 100,000,
It's a 1 or
Is it-
2%. It goes to mainly apartments and all that, a third party, and it's a group mail out is what it
Yeah.
is from the mail. So they probably don't even get it on time. So it's bulk mail is what it is.
and what these companies do, they come in and they talk the dealerships into doing them. I mean, that's what, I did one years and years ago, never did another one. And they come in and they talk you into it about what they're gonna do and what it's gonna produce and, but we don't hold these people accountable is the problem at all.
I
We
think
don't
it's,
have jurisdiction over an advertising agency.
and I think it's hard to find those people. They're
In another state,
in another state and
but they send their people to our state.
living in a hotel maybe. I mean, you're not going
Oh,
to
they're
find those
living in
people.
a
They're very shady. So.
Yeah, they are. But they do get licenses, or they used to. They used to apply because you could get it that day and get it sent, but they'd be gone before the license even, really took effect. So I don't know how many of them actually did get the license, but I just know that it is a bad practice. I don't personally like it, and I can only speak for me.
I guess my question to staff would be, if we decided we as a commission are going to come down hard, I call these super sales. That's always been our anecdotal nickname for these type of sales. When you send out the mass mailers and you bring in the third-party salesman and it's questionable gifts and all that stuff, which obviously my store doesn't do that. But early in my career, I worked some of those things, and it was always really not a very good, kind of like what Commissioner Roberts said. If we decided we want to start coming down hard on these, how could we get word out? Because this is, some people, we do 3 super sales a year. This is what we do. This is our marketing budget, and not blindside them if we're going
But
to
they're
start.
lied to by the advertising company that they check the boxes for validity, that they're right, and the dealer falls for it.
Yeah, I don't know.
They do.
Well, and I'd like to add, I mean, this is one of the things that, when I mentioned earlier, that Erica, Jason, Taylor, and I were gonna be working on some guidance that we can post on the website. It's hard to just direct it at like this Monopoly game, because you never know who's gonna come up with what. There are a lot of clever people out there, especially when it comes to circumventing the law. So, we're gonna work on something that we can post on the website, and what I'll do is when we get that and get that approved through all of our, resources, we'll do, an email blast as well to all of our licensees.
Okay.
Hopefully that will help.
So it seems like this is a fairly common practice in the industry. I know I've received these all the time. I don't believe that they're anything and just throw them away, but fine, 1% doesn't. But what is the law being violated? I think you said from our discretion, if our jurisdiction's over the dealership, and if the dealership is using something which we find to be misleading, then we can punish the dealership. But since it's so widespread, I agree, shouldn't there be more of a decision by the commission, decision by your department to say, we think these games of chance, these essentially fake games of chance, are misleading, and that's how we're going to enforce them going forward, so use them at your own risk. But before we've done that and communicated that, it would seem hard to just now say, nah, we're going to start fining for these things now that one or two consumers got confused.
Commissioner Galvin, can I make a recommendation? If we can bring Jim Cameron in here, because he knows all about these sales, he knows all about the gimmicks, and he's good about dissecting all of this, he can give us guidance to say, hey, this is what you need to do, because he is the guy that knows all about this thing right here.
Agreed.
I will say that we find, in the last year, we've fined 2 dealerships for very similar games. So we've done it before. They were $5,000 fines for each complaint.
Is there something particular about this one or those prior ones that we feel crossed the line that was not like the rest of the games, but this was now improperly misleading?
I think we were able to look at them, like the consumers were able to provide them with their complaints, and we were able to, the commission was able to make a decision based on the description of the game, and now looking at it, that it was deceptive on its face, just by reading the wording. It doesn't, it's not clear, just the definition of deceptive. I don't think we've ever had a complaint against them where we have had it, we've had the actual copy of it presented where we didn't find them. We just haven't had, I don't think we've had a lot of people provide the actual game itself.
So in this specific instance, going to the first slide, if you've got those 3 houses, you get a $2,000 Amazon gift card. Arguably, the asterisk doesn't get them away from it. So I think what we're saying is, in this situation, this consumer was promised $2,000, which they didn't get, which is misleading, and we're going to hold the dealership responsible.
Right.
Have you actually even made them produce proof that someone will win or that there is a number?
Well, I asked a lot of questions about it,
There's a
trying
disclosure
to
at the bottom.
get those
It says
answers for you.
1 out of 500 will win
Okay.
this. I mean.
Well, that 500,000, you mean? Yeah.
And I think Erica was about to say, she actually asked those questions
You
and
did?
got answers.
Okay.
And I believe, if you'll look, it says they provided a list of winners, which included 1 winner of a $1,000 Walmart gift card and 1 winner of the $2,000 Amazon gift card. Neither winner showed up to claim the prize, which I'm sure is very typical when you're sending out 100,000.
And only 1,000 come in.
And what I was gonna share with everyone is, unfortunately, we don't have the staff that we need to be able to go out there and aggressively seek these kinds of things out. Unfortunately, we're responding to complaints, and it just so happens that we had 3 from last year in 2024, and then these 2. Actually, both of these came from the Consumer Affairs, the Director for Consumer Affairs at the AG's office, because they share an awful lot with us and didn't know if this was something that we could look at. And interestingly, after I got these 2 from Claire, our Assistant Commissioner sent me a text message and said, I just got this from blah, blah, blah. We need to look into this. So, I mean, he had seen someone out and about, and they shared the same thing with him. So I don't know who that was. We, can't base that. We can't create a complaint based on that. But I think, obviously, like Commissioner Galvin said, it's just a whole lot more prevalent than most people are aware.
Is there not some type, like, I know as a dealership, I can't do off-site sales. And while we got a worse name for them than super sales, is there not a way to just make this type of, where you have a crew come in to do a sale, or is there a way that we just can't allow that to happen?
Well, if you want it to be as clear as that, you would just amend your rule and add detail about not allowing this kind of promotion or sale to happen because it's deceptive or misleading or both.
The one thing that, as much as I don't like these sales, there's not anybody in here I don't think that likes them less than I do. But again, you had 2 winners in the mix of it, so they're meeting definition of legitimacy to some degree, but yet it's still a trick and device because it's unclear when they call in whether, they're told they won, okay? And then that guy says, well, you may not have won.
Right, like, to me, that is the part of it that is deceptive. And
Yeah.
then you have to go to the dealership, so you can't just call, you also have to go and match it to a prize board. So I don't understand how all of those three things can be true at the same time.
Yeah,
It
so how
is-
do we do something legislatively to ban this? Or can we do it on our own? What can we do?
Well, as Erica mentioned, we can amend the rules, but I will remind you all, as testament today, how excruciatingly long that process is.
Oh, yes.
We started out you guys approved rules in April of 2024 for fee increase, and it literally went into effect in September of this year. And hopefully our retrospective rules won't take that long, but they're just a little cleanup things that aren't terribly vital. But I don't know. I don't have, and I think what I wanted to mention is that I think we certainly could ask Mr. Cameron to come and during the public comment period, make some comments and observations.
Should we put off making a decision until Jim Cameron comes before us and advises us what we can do and what his thoughts are on the matter?
I would say we have a precedent that we have fined people thus far for this exact same issue. So for this specific complaint number 69 or whatever, I say we can pull the trigger on some form of fine because we've got precedent from previous people.
Yeah.
Okay.
Yeah, and let me ask the question this way, because, I mean, we've got an egregious sales practice here that's bad for the consumers, and that's our job here is to protect the consumers, right? And I guess as a staff, I've heard y'all mention, there's a staffing issue in terms of having the personnel to enforce this consistently in a widespread way. We've mentioned that we've got an education issue with some dealers, I guess, being willfully ignorant, because I don't see how any automotive professional could not recognize this for what it is.
I completely agree.
I think it's some degree of what they're looking for is maybe plausible deniability that, oh, I thought it was okay.
Right,
And
or they
then-
rely on the advertiser to make sure it's legal.
And then we've also talked about a rules issue. Like, do we have rules in place to enforce this? And it sounds to me like it might be a little bit more of the first two than the third one. But I guess I'd appreciate y'all's insight on that, is how do we protect the consumer here? And do we need, a focus or personnel, or do we need communication to people, letting them know the chance they're taking? And do we need to publicize the fine for the chance they're taking if they lean into this kind of promotion? Or do we actually need new rules in the books because y'all feel like you know about it, you just can't do anything because you don't have the structure in place?
I think, well, I know you're asking them. Yeah, sorry.
Well, I don't know if this would change anything, but I want to mention, I talked about our rule, the advertising rule, where you have a lot of discretion because it states if you find anything as misleading or deceptive, it's a violation. But in addition to that, I would argue that the Consumer Protection Act under 47-18-120D1, it states that it's unlawful to require a consumer or a person who receives a prize or a promotion like this to, It is unlawful to require a consumer or person who receives a prize, gift, award, incentive, promotion, or anything of value in a contest to incur any monetary obligation outside of a nominal postage cost in order to determine what prize they've won or in order to remain eligible. I would argue that having to drive to a dealership is more than a nominal postage cost. So we have that, which I think is really clear. That doesn't sound vague to me. And if you read that law, then you're being willfully ignorant in trying to make the argument that this game is not a violation of that Consumer Protection Act statute.
So it sounds like we don't need new rules. It's more of an education and enforcement question in front of us. Is that correct?
Yeah,
Or at least
yeah.
do you think?
I think so.
So if that's the case, I mean, maybe making a good story out of this that we can spread and then continuing to enforce this and getting the word out that we're enforcing it might be the best way to protect the consumers.
And I will add, just for the record, and Erica certainly can chime in, she and I both, when the manager of this store received this complaint, they were very responsive and reached out. And then the dealer, there was some communication back and forth between Erica and the manager. And then the dealer, the owner, reached out, and she and I both talked to him, and they were very concerned, and they obviously want to be compliant. I don't think they're trying to avoid responsibility, but I just wanted to make that known, that they did seem they asked, what about this advertisement is misleading or deceptive? And I said, if my mother received this and she had 3 red houses in a row, I think she was going to win an Amazon gift card.
I think we have two issues. I think there's one immediately what's in our authority right now to manage, which is this deceptive? This, of the 1,000 people that responded, of the 2 people that actually got the 3 houses, that actually reached out to staff and have brought it to us today, I think we can all look at this and make a decision, is this deceptive? And then what's the prior penalty based on that? Yes, this is gonna become a story if we make some sort of a penalty issue, but then the second part is, as an industry, and this is for y'all, how do you want to make clear to everyone, that's the chance you run. If you listen to these advertising companies and they talk you into doing something really stupid, and the commission, it gets all that way, and the commission decides it's deceptive, there's probably gonna be a penalty there. Now, maybe you sold a bunch of cars so you don't care. But we, as an industry, probably should come up with clear guidance on that we're not gonna allow these, or this is what has to happen, or these are the rules, you have to at least follow the Consumer Protection Act. But for what's in our authority right now, it's for us to decide, in these 1 or 2 cases, I can't remember if they're combined, is this instance deceptive, and for that, what is the penalty based on past practice?
Well, I'm okay with us being consistent. If we find, let's just figure out how much we think should be fined. But also, let's remember, all of us dealers that sit at this table, it's a warning to all of us that we turn over our dealerships to these, I call them thugs, that come in and run our stores, and they desk the deals, and they bring their salespeople in, and our people have to sit in the background and just kind of watch it happen. Now, this is 20 years ago. I did it one time, and like I said, I swore off of it. I didn't like anything that it looked like. It just wasn't what I was sold it was going to be. So I just said, I'm done. But there should be a warning that you need to stay in control of your store and not turn it over to an outside source. That should be part of it.
And I feel like we will always have licensees making the argument, I didn't know it was a violation because it's not laid out clear as day that it's a violation. That will always be there. When you have a statute like, if something's misleading or deceptive, that is somewhat vague. But it also, I think the intention behind it was to allow the commission to make a decision about things like this. Because we cannot, in our rules, prohibit everything anybody can ever think of. It's just not possible. So I think a dealer, a licensee has to have some responsibility in making good decisions about how they advertise, who they allow to come sell in their store, and use their common sense. To me, this is common sense. You look at this and it looks deceptive.
So we determine it's deceptive, what's the fine, $1,000? Because that's not gonna do anything.
Well, in the past, we've done 5,000, which is the maximum civil penalty for a single violation, which I thought was fair for a first-time offense like this. And since there's the argument that it's not laid out for them, that they can't do something like this, I felt like that was a fair, more than fair civil penalty.
So it's not $1,000 per mailer like it is $1,000 per sale?
I mean, it could be.
It could be.
It could be.
Could be a lot of things.
It can be whatever you would like it to be based, within our allowable civil penalties, which is anywhere from 0 to 5,000 per act per day per violation, whichever you choose.
Yeah, so how would define the violation? And I will make the comment that not knowing the speed limit has never gotten me out of a ticket.
Right. That's why, I just think that you've got to do your due diligence. You run a business. I understand you're going to make the argument, your attorney's going to make the argument, but you have to make good decisions. And I just think this, trying to get out of it because it's not directly prohibited is not a good argument.
And keep in mind also, when dealers do this Mickey Mouse sale, they make tons of money. I mean, they gross a lot of money. And these people that come to these sales, they walk out with a lot of money, you never hear from them again. And then you start getting reviews, and then, people coming back and asking for this guy, oh, he's no longer here, da-da-da. It's a mess, but they make a lot of money, so don't feel bad if it's more than $1,000. We need to up the ante way more than that. I mean.
So what were the prior fine amounts last year?
5,000 for each complaint. So we have 2 complaints here. And I just recommended discussing 5,000 for each complaint, which would be a total $10,000 civil penalty. And that is
But we've
consistent
had a
with what we've
history
done
of 5,000
per complaint.
Per complaint.
per complaint.
So we had one dealership in the past that had 3 complaints. We issued a $15,000 total civil penalty. Because we had 3 complaints against them for the same game that's really similar. And then we had another
And
separate dealership.
how many did we have on this one?
2.
2?
2 complaints about this game.
Just from my perspective, right, relatively new, a few times I've heard us discuss that there isn't enough, the ROI, right? Like, if this campaign costs $100,000, I don't know, 100,000 mailers, like, who cares about, that's a 5% sort of buffer if the penalty's only 5%. It feels like, and I don't know how the rules work, we should start looking at this as an ROI, right? If a person makes a $100 ad and they screw it up, probably shouldn't be fined $100,000. But if they're risking a $100,000 ad campaign, they should be scared. Otherwise, just go ahead and take the risk if it's only a $5,000 risk. I mean, I've heard you guys say similar things about other campaigns that are so lucrative that there's not enough weight in the penalty.
I guess I would say the other side of that is, if this same outfit does it again, it ain't gonna be $5,000. It's gonna be, so usually, we're very good at coming down hard on second-time offenders in this.
Yeah, I think that's where we more need to go with this, is the first one, let it be a 5 or something or whatever, but then give them a letter of instruction and monitor them at least, because some of these people like to do them as part of their whole budget. They just want to keep doing them. They'll do 3 or 4 a year, and we need to monitor it so it doesn't happen again. We need to shut it down where we can, because the consumer is getting hurt.
Commissioner Norton, I agree. Oddly enough, the last 6 months, I was offered this by, I don't know if it's the same person, but I vetted it, considered it. Obviously, would never do it. It's deceptive. I even went to each of the stores. They referred to me, and I talked to some of their sales managers and I talked to the banks who do these deals.
Mm-hmm.
It's really deceptive. I mean, it's a bad. I would never ever do this. It shows signs of desperation, like I think you said, about trying to get out of a non-profitable situation or move inventory, something like that. But I signed up or was part of this commission 10 years ago, and I did it for a reason. It's what our mission statement says: level playing field, empower the consumer. And I think that's what our obligation is here. And I mean, there you can look at fine print, but clearly it's deceptive. And I think I concur. I just want to make a comment. I think we should do something about it. I agree that I think the fines should be consistent throughout. Like Commissioner West said, if they reappear, it's a little more severe the next time. But this, ladies and gentlemen, this makes us look bad in the industry. This is bogus and it's deceptive, and I don't condone it in any way. And I mean, I'm actually happy that the dealer showed remorse
And I'm happy, I wouldn't know who it is, but I'm just saying, I'm glad they show that they want to do something different about this. But yeah, I like the way this is going because, trying to keep this, empower the consumer and keep our industry clean, which is important. That's why I come spend time here. I think it's important we do these things to keep it clean, and I'm committed to that. I think this body is too, so I think our actions head in the right direction.
So as a commissioner of the Motor Vehicle Commission, if I see a dealer or if I get a mailer, can I approach that dealer and tell him or I'm not liable, tell him I'm on the commission or anything like that? How do I approach somebody and say, hey, you better stop doing this?
Well.
You wouldn't.
Well,
You wouldn't.
I would recommend
Right?
anybody
Because I
who's
signed that paper at the beginning, yeah.
I would recommend anybody who's concerned about possibly deceptive advertising filing a complaint. So it can be handled in the standard, we can
Let the
follow our
staff.
standard procedure. Everybody gets treated fairly, but nobody can stop, anybody from doing what they want to do. But that would be my recommendation, so that everything is done correctly and justly, ethically, and fairly.
And Sierra will touch more on this during her presentation, but all commission business needs to be discussed in a public forum. So you can't be speaking to anybody about that directly as a commission member.
That's right.
And just based on everything I've heard and your concerns, I would just recommend that we consider being consistent in our fine. And now that the commission's had a chance to look at one of these, and the public can watch this, dealers, licensees can watch this, we can do a blast email to put all licensees on notice that the commission has made a decision based on this kind of game, this kind of advertising, and you'll be risking a so-and-so civil penalty. We can also put something that's on our website that's permanent. And then after that, I think if you want to decide, we want to find more because we think this is such a problem, we want to, be more harsh with our penalty, I think that would be the time to do it, not necessarily now. If, just based on what I've heard you be concerned about.
Yeah.
I got a question. Of course, we don't have any jurisdiction over the vendor, but does the Attorney General have jurisdiction over this, over the vendor?
Well,
It's deceptive.
you mean the advertising agency?
Yeah.
I would think so. Honestly, the licensee didn't give me enough information about that advertising agency for me to
Well, I
give
think
you
the
educated answers.
advertising agency is just as bad, if not worse in the case, because they're selling the dealership on it and the legality of it.
Well, and I'll say, when Erica and I had a conversation with the owner of the dealership, the advertising agency was mentioned, and we offered happily to meet with that advertising agency to provide some guidance. And I'm gonna have to follow up with the AG's office and find out what, if anything, they did other than allow us to move first, since we were more the commission with jurisdiction. But I mean, I would think they have jurisdiction as well over.
The vendors.
But for today, we don't have jurisdiction over this commission. So now that we've had this discussion, what would staff's recommendation be for 69 to put into the report for us to now vote on, along with the other changes?
I think based on what I've heard, that I feel like it's pretty unanimous that everybody in the industry themselves believes this is deceptive advertising, does not like it in the industry. And based on our past civil penalties for similar games, my recommendation would be $5,000 civil penalty for each complaint, which will be a $10,000 total civil penalty. And the program, immediately working on some education through email and possibly posting on our website. So licensees are put on notice that this is how the commission feels about these.
Erica, just a question on this. Is there any mitigating circumstances that would differ this one from the ones in the past?
Well, since you asked me that, I feel what I've gotten from the past dealerships that have done games like this was immediately acknowledging that this is deceptive. We shouldn't have relied on the advertising company, and we will always have a lawyer look over something like this if we do it in the future. This time, the licensees seemed to not understand that it was deceptive and want it to be made more clearly in the rules that they can't do something like this. And kind of, we relied on the advertising agency to make sure it was legal. And so I would say it's the opposite of mitigating.
That's just a cop-out. I mean, they're being naive. You know.
So do we agree to have Jim Cameron come in next for a
Yeah, I
public
still
hearing?
think we can invite him. But that's separate.
That just gives the idea, separate, right?
Just to clarify, he cannot advise directly on this complaint or speak about a complaint directly, but he can come during the public comment period and speak about this issue as a whole objectively and give some information on his research into this issue.
I'm good with that. We'll do it that way.
And I'd make the observation that as Jim is partially retired now, there's J.D. Mason and a number of other qualified attorneys that can similarly speak on this.
So are there any other changes to the current legal report other than the ones we talked about before, the recommendation on the 5,000?
Separate, and then,
By
and then I'll give
we'll
the-
add it to the rest of the legal report.
And then we'll do the rest of the legal report.
Okay.
Have a motion?
And what is the motion?
It's a motion to uphold the staff's recommendation for number 69.
And that's $10,000?
$10,000.
Is that all it says? I can't remember what it's, I didn't read the rest of it. Is that it, or is there a monitor factor in there?
It's just a $5,000 civil penalty for misleading, deceptive advertising for number 69. And then the other cases.
Can we not add the monitor to keep them from doing it in the future?
Well, I don't know
Or is
how we
that-
would monitor it because
Okay,
we wouldn't know about it until it was out and somebody would have to tell us. I don't think this is something that can be monitored. with
okay. Okay.
What we have. We can monitor our website, but
But a
we
letter
can't
of
monitor
warning?
things that are mailed.
But a letter of warning, we can do that.
Well, with
Fine
the
is,
fine
yeah.
will come terms in a consent order if they choose to sign it that makes it clear they have to cease and desist this kind of thing. They're agreeing to ceasing and desisting it.
Okay.
If they sign it.
That's good.
So the motion is to uphold 69.
I'll second that.
Any further discussion? We can do a plural vote. Plural vote, is that okay? Plural, just out loud, voice vote.
Voice vote.
Yeah,
Okay.
voice.
Okay, the motion is to adopt staff's recommendation for a $5,000 civil penalty for each complaint, which would total $10,000 for this particular dealer based on deceptive and misleading advertising. And it was made by Commissioner Norton, seconded by Commissioner Andrews. And
So any further discussion on that? Okay, all those in favor say aye.
Aye.
Opposed? Okay,
perfect.
now let's go into the rest of the legal report.
I'll go over the other changes made during the legal review committee. Number 33 and number 39, the civil penalty is going to be $5,000 instead of $10,000. And number 42, instead of a letter of instruction, it'll be a $1,000 civil penalty and require a respondent to provide the commission within 30 days that their website's been updated for their advertising violations. And those are the only changes made.
Okay.
I make a motion to approve the amendments to the legal review.
Any further discussion? Executive Director Lawrence, we call the roll on this one, on the vote?
Yes, sir. The motion to adopt the legal report as amended, including the change to number 69. Commissioner Levy?
Aye.
Votes aye. Commissioner West?
Aye.
Votes aye. Commissioner Elam?
Aye.
Votes aye. Commissioner Rydell?
Aye.
Votes aye. Commissioner Morgan?
Aye.
Votes aye. Commissioner Young?
Aye.
Votes aye. Commissioner Copenhaver?
Aye.
Votes aye. Commissioner Andrews?
Aye.
Votes aye. Commissioner Karas?
Aye.
And I believe
Accept.
Commissioner Karas is voting aye on the legal report with the one exception of number
Number
16.
16, yes, ma'am.
Noted. And Commissioner Yarborough?
Aye.
Votes aye. Commissioner Galvin?
Aye.
Votes aye. Commissioner Norton?
Aye.
Votes aye. Commissioner Kramer?
Aye.
Votes aye. Commissioner Evans?
Aye.
Votes aye. And Chairman Roberts?
I accept 58.
Got it. The motion carries.
Okay. Legislative updates.
We don't really, obviously, the legislature is not in session, yeehaw, but they'll be back in January, so don't get too excited. I thought I might let, and I don't know if he wants to do it now or at the very end, let Tim Slattery with TAA and John Davachi with TNIADA to give us some updates on things that they see on the horizon. Maybe ask Commissioner Norton if he has an update for us on electronic titling.
That could be in this section also. It can be okay. Anybody?
No, I don't have an update. I have been in touch with the staff, the state staff on the electronic titles. It is due to roll out June 30th, 2026, and I have spoke with Tim Slater about this. He's probably got a lot more information than I do. He's been interacting with the legal staff, but I'm just optimistic that's going to happen. It's going to come in on time, and it's going to be very beneficial to the state of Tennessee. The fact of getting tags quicker through the county clerk's office with data inputted at the dealership level, with title issues as far as previous states. Hopefully it'll help us clean up some title washing. So I'm really optimistic that it's going to come in, and but I don't have a lot as far as a general update. I have listened in a few calls as far as the progress, and they are making progress. Would you agree, Tim? Making progress. That's all I've got.
So with the associations, when y'all comment, just try to keep it brief as you can. Thank you.
And I think the last thing on our agenda before Sierra goes into her open meetings presentation is, I think you have under new business advisory opinion, and I just wanted Sierra to share with you some information that we're going to be providing you at a later date.
Okay.
Good morning.
That's-
So
go
we
ahead.
received a request for an advisory opinion. For those who don't know, an advisory opinion is like it's a written decision analyzing how a law or rule applies to somebody's particular situation. We received it from, I'm sorry. So an advisory opinion is like a written decision analyzing whether a law or rule, how it applies to a particular person's situation. So we received a request for an advisory opinion from an auction. So me and Denise and I are working with the Auctioneer Commission to get this question answered. We did send it to upper management, who has a few additional questions. So we wanted to present it today. However, it's not ready to be presented today. We just want to let you know beforehand that it will be presented in the future. We are just doing additional research at this time with upper management.
Okay.
And we may ask the members to either, I'm not sure yet, we have to discuss this and see where we're going. I don't know if we'll call a special meeting, if we'll try to do it remotely, or let you all look at the advisory opinion when it's complete so that we can get a timely response back to the individual who's requested it.
Just let us know when it gets closer. And Tim, sorry about that. You're ready to speak to us.
Tim Slattery, President of Tennessee Automotive Association. Just wanted to share a few updates. We traveled the state over the last few months and did 6 meetings. Had over 300 attendees, most of them dealers. We also had vendors and other folks attend. Some of the things we highlighted were what's going on in Washington. There's obviously a lot of change on with electric vehicles, both regulation as well as the credit going away September 30th. We also want to thank the staff. They came to our motor vehicle commission, or came to our Nashville meeting and presented on some of the key topics. Things we mentioned in those meetings, and I think the point was raised to make sure we continue to educate our members about compliance. I highlighted one, responding within the 30 days. If you do receive a notice from Motor Vehicle Commission, updated the highlighted, the change in fees. And then there's one more I'm blanking on, but we appreciate, we're always ready to play the role as educating our members, just making sure they understand. And we aren't necessarily constrained by the rulemaking process. We can get that information out quicker just to put it on their radar that these issues can be coming. So appreciate the commission's role and everything you do. Thank you.
Very good. Thank you.
Thank you, Tim.
Next.
Morning, Chairman Roberts, Executive Director Lawrence, Commissioners, Commission, John Davachi, President of TNIDA, the Tennessee Independent Automobile Dealer Association. I'll just be brief on the public comments. Just wanted to make an announcement that the stage is set and confirmed for our convention, our state convention on 11/11. We are partnering with the National Association. We got 35 vendor partners participating, about 25% of our total association members signed up to attend already. We are doing our convention at the Lowe's Vanderbilt Hotel on 11/11. Definitely want to welcome anybody who desires to attend to come. We would love to have you there. We are rolling out an education platform out there at the convention. We eventually hope that you'll see the prospects that apply for the dealer license, perhaps make an attachment on their application with that certificate, and also continuing education for the existing dealerships. Just a couple of notes to highlight at the convention. We'll have Senator Jack Johnson speaking at 12:45 to 1 p.m. We're grateful to have guest speakers of Ms. Denise Lawrence and Commissioners Stan Norton there participating and speaking. We'll have some education sessions for that one-day event. We'll include topics of state tax law, reconditioning and service, the federal law, navigating the FTC rules. We'll have a session on AI and marketing, about the strategies and rules about that. A panel highlighting some dealer success stories, and also a session about title and transportation fraud and prevention and best practices. We've had several independent dealers this year have vehicles stolen from transporters, basically, fraud and deceptive. So there's going to be an education session on that. I also want to highlight our executive director, Ms. Karen Brown, here in attendance today. She and a few of our board members did attend the policy conference in D.C. This past month, where they met with Representative Tim Burchett, talked about some catalytic converter theft, the right to repair, and just advocating for dealers here statewide and nationwide. That's pretty much all I got. I appreciate all of you speak.
Okay. Thank you. Thank you. Anything else, Denise, that I'm, okay. Sarah, you got more for us?
I'm going to try to run through this quickly. However, if you guys have any questions, just interrupt.
Okay.
So this presentation is regarding the Open Meetings and Public Records Act. So the goal of both laws is governmental transparency and making sure information and events are public or done in the sunshine. Hence, the title of this presentation, You Are My Sunshine, My Only Sunshine. So we will start out with a disclaimer. So I won't read all of it, but it basically states that the information provided in this presentation is not legal advice. If you have any legal questions related to the presentation, let us know. Also, the information in this presentation is not all encompassing. So there may be additional information not included in it. But again, if you have any questions, just let any of legal know or Denise. So the Public Records Act. So we receive requests for public records regularly, and the requesters can ask for a wide variety of information. But what is considered public records? Public records includes documents, media, or electronic data processing files and output. This is a very broad category. So if you're trying to figure out whether something is a public record, I would say the default is that it likely is. What is not included are devices or equipment where records are displayed, such as your iPads or my computer, However, keep in mind that the information on the equipment can be a public record. Next, we'll talk about the Open Meetings Act. Overall, this law requires government bodies to conduct their business in public. There are four things that we'll discuss regarding the Open Meetings Act. First is, what is the act? First, the General Assembly declared it to be the policy of the state that the formation of public policy and decision is public business and cannot be conducted in secret. The reason this presentation, oh, you know the reason at this point, why it's titled "You Are My Sunshine." The act does not limit any privileges or rights contained in Article 1, Section 19 of Tennessee's Constitution. The goal of the act is to promote openness and accountability in government to protect the public's interests. Based on its goal, it is best to interpret the Open Meetings Act broadly. So the Open Meetings Act requires that all meetings of any governing body be open to the public, except as provided by Tennessee's Constitution. This includes emergency meetings, committee meetings, and of course, our board meetings. So the two requirements are, one, there must be a meeting, and two, that meeting must be of any governing body. So just starting with number 2, it's a little backwards. What is a governing body? A governing body is any public body consisting of 2 or more members with the authority to make a decision or recommendation. For example, if board member 1 and board member 2 go to lunch, that is technically a governing body. Again, there must also be a meeting. Meeting means the convening of a governing body of a public body for which a quorum is required to make a decision or to deliberate towards a decision on any matter. A meeting does not include someone coming in to inspect our documents. Oftentimes, when we are fulfilling public records requests, we will send the responsive records to individuals electronically or via mail. However, requesters also have the option to come into our office and review the records. They can take notes, however, they cannot take the documents with them. Overall, any inspection that occurs and relates to the board is not considered a meeting. This means inspectors cannot, in conjunction with the inspection, deliberate towards a decision. This would also include audits. A meeting does not include a chance meeting of 2 or more members of a public body. However, these chance meetings cannot be used to decide or deliberate public business in circumvention of the spirit or requirements of the Open Meetings Act. So 2 or more was also not a meeting. 2 or more members of a public body sharing a meal together in which public business is not discussed is not considered a meeting. Lunch breaks, restroom breaks, smoke breaks, recesses between morning and afternoon sessions, and adjournments between days of a multi-day meeting are not considered a meeting for purposes of the Open Meetings Act. And during these events, board business should not be discussed. Regular meetings and special meetings count as open meetings, but the exception to this is executive sessions. So an executive session is an attorney-led meeting with 1 or more board members in attendance. Usually these meetings occur when the board is under the threat of a lawsuit. It's an opportunity for the attorneys to inform the board of what is going on, and the board can ask questions related to that matter. Because it is not considered a meeting, it is not subject to the requirements of the Open Meetings Act. However, during these meetings, decisions regarding litigation cannot be discussed. But keep in mind that executive sessions are pretty rare. During executive sessions, the board may not deliberate about any specific matter before it or potentially before it. This slide talks about a case related to the Civil Service Commission of Maury County, and it states that people applying for jobs within the classified service of the Maury County Sheriff's Office come within the provisions of the Open Meetings Act. This case is mentioned because that is a testament to how broad the term meeting is for purposes of this act. So just looking at some examples of what is permitted under the Open Meetings Act, if a member emails the chair and states, here's a news article, or I'd like something included on the next agenda, that would not be considered a meeting. What would be considered a meeting is if a member emails the chair and states, here's a news item about one of our licensees, we should consider revocation. This is why when Denise emails you all things, you are blind copied on the emails. If you were CC'd on the emails, that would be considered a meeting, and that information would need to be disclosed publicly. So on that note, if you are emailing Denise, you would want to make sure that another board member is not included on the emails, and if possible, CC an attorney, me, Erica, or Taylor. If you CC us, the attorney-client privilege may apply, preventing disclosure depending on the subject matter. Next example, if a member emails me, Erica, or Taylor stating, I have a question about the legal consequences of something the commission has done, that is acceptable and we can answer that question. What is not acceptable is if you contact us and say, I've taken an action as a commissioner and now someone is upset. Again, as a governing body, you all should be making decisions together at an open meeting. One member cannot make unilateral decisions on the board's behalf. I just want to, there's a side note, you are allowed to tell people you are a board member, and you can speak in your individual capacity. However, like I said, you can't speak on behalf of the board. Next example, if a member sends an email to another commissioner or calls another commissioner, that is not a chance meeting. Even if you do not discuss board business, we should avoid this because it gives a strong appearance of impropriety. So if there's something you need to discuss with a fellow board member, try doing it during the meeting setting. For those of you who have already gone through this presentation, this information is new. Previously, we needed a physical quorum in the building for meetings. However, pursuant to the Less is More Act, an absent member may participate electronically, but all votes must be taken by roll call. This is so the public will know how any given commissioner voted on each issue. In these situations, we do want to make sure everybody introduces themselves before speaking, so members of the public can track who is saying what during the meeting. So if you appear via Teams, you would just need to identify yourself prior to making any statements on the record. With the Less is More Act, a physical quorum is required at least once per year, though, so all the meetings cannot be electronic. As previously stated, the act is to be construed most favorably to the public, is all-encompassing, and applies to every meeting of a governing body except where the statute explicitly excludes its application. The public has a right to attend, observe, and make comment at our meetings. Public comment is to be permitted at each meeting and is limited to items listed on the agenda. And as far as it only applying to things listed on the agenda, that is construed liberally. If the comment is within the jurisdiction of the commission and it's germane to the issues we are discussing, a public comment is most likely going to be permitted at that time. The meeting notice is not something you have to be concerned about, but we're going to discuss it anyway. So the Open Meetings Act requires an open meeting to be noticed. There is a three-pronged test for determining whether the public notice is adequate. It must be reasonable, sufficient, and it must be posted. Generally, for a public notice to be adequate, the contents of the notice must reasonably describe the purpose of the meeting or the proposed action to be taken. I would think of it as a notice must be descriptive and not written generally. What makes a public notice sufficient? The notice must be posted at a time sufficiently in advance of the actual meeting to give citizens an opportunity to become aware of and to attend the meeting. To be adequate, the public notice must be posted in a location where a member of the community could become aware of such notice. The two usual methods are internet and newspaper. Our usual practice is to publish notice of meetings on the board and the department's website. Posting a notice online in a way that complies with the Open Meetings Act is contingent on facts and circumstances behind the posting and whether the location would be one where members of the community could become aware of the notice. Whether public notice is adequate is an all the facts and circumstances analysis, and no single factor is dispositive. So if someone challenges the notice, we'll be considering the three different factors in order to determine whether the notice was adequate. There are two penalties for violating the Open Meetings Act. The first is nullity, meaning that anything the board did during that meeting is null and void. The second is costs and attorney's fees. So if someone asserts that the board violated the act, they will have to bring suit. If the board loses, then the board would be liable for the party's costs and attorney's fees. So in a nutshell, the Open Meetings Act is designed to ensure that all board business is conducted in a way that is accessible to the public. It applies to you both as an individual member and collectively as a board. So all gatherings of more than one member are meetings and are covered by the act, including regular, special, and emergency meetings, and including committee and subcommittee meetings. And like I said before, executive sessions is the only exception, and adequate notice must be given for the meeting. Any violative acts are void, and costs of litigation and attorney fees may be assessed against the board. And then the next thing we'll talk about is the Supreme Court case, North Carolina Board of Dental Examiners versus the FTC. So in this case, the Board of Dental Examiners issued 47 cease and desist orders to non-dentists who were performing teeth whitening. The FTC argued that the board violated the antitrust laws by unilaterally ordering non-dentists to stop providing whitening services. The board argued state action immunity, but the Supreme Court sided with the FTC. The Supreme Court held that the board didn't receive active supervision by the state, and that state agencies are not simply by their governmental character sovereign actors for purposes of state action immunity. So what is active state supervision? This inquiry is flexible and content dependent, is whether the state's review mechanisms provide realistic assurance that a non-sovereign actor's anti-competitive conduct promotes state policy rather than just the party's individual interests. Overall, we want to ensure we are adhering to our mission, which is consumer protection. Just a reminder, we don't protect the industry. Now, that doesn't mean that the interest of the industry is irrelevant, of course. That is why we have rulemaking hearings. What we don't want to become is protectionists of our industry. What is the impact of the case on Tennessee? After North Carolina Dental, there was a statute passed in Tennessee which establishes supervising officials. A supervising official is a commissioner or CEO of the administrative department under which the regulatory board operates or to which the board is administratively attached, or a supervising official is a commissioner or officer's designee. For our purposes, our policy director is a supervising official. She reviews all the meetings and if something stands out to her as being an anti-competitive practice, she'll notify us. So if we're doing something that curbs participation of non-licensees, we need to have a clearly articulated state policy behind it to support it. In the event this occurs and an action requires further review, we would inform the board within 10 days that the action is subject to further review. We would then review the full evidentiary record regarding the action, and if necessary, supplement the evidentiary record or direct the regulatory board to supplement the evidentiary record. We would then review the substance of the action, and in writing, the board would need to either approve the action, remand the action, or veto the action. Last one. If you have any questions, whether it pertains to this presentation or something else, feel free to contact me. My contact information is up there, and I'll leave it up there. Does anybody have any questions?
When you mentioned the public records, has this commission ever considered issuing commissioners.gov email addresses to help prevent the commingling of public records with our private email?
I don't think so.
I don't know the answer to that question, but it's a good one, and I'll see if I can find out.
Okay, anything else? Want to, before we end.
One question.
Okay.
Are we allowed to have lunch together or not?
I'm sorry. Yes, you can. Just don't discuss board business.
Yeah, that's
Period.
it. It's that
Yeah.
simple. So anyway,
No.
you need, okay, go ahead.
I have one thing that I need to say, and she's already gone, but I apologize to our newest commissioner, Tricia Jung, because it is pronounced Jung and not Young. So I apologize.
And hopefully she'll be here in person next time. I was going to speak to her and thank her for being willing to serve, and we'd see her the next meeting in person. But also we have, with sad news, with Commissioner Elam has decided not to keep serving. And I just want to thank you for your service. And you really taught me a lot about what goes on in the clerk's office from your experience there in your early days with us. But thank you for your time.
Thank y'all very much. Everybody's been great. Thank you. I have really enjoyed it and learned a lot, definitely learned a lot, and representing on the consumer side, because I have a heart for both the consumer and the businesses, because both there's bad thing, corruptness on both sides. I mean, when it comes to what a lot of consumers do to dealers as well. So it goes both ways. So just thank y'all, because everybody's been so great. And I will say I was a little intimidated by coming on this board. A lot of people with a lot of serious backgrounds, something that I do not have other than just serving with the county for 38 years in the motor vehicle division. So it was really good. And I did want to just add one thing that, and this is probably pointless, but I want to say, again, coming from a consumer, but also I think I can speak for the dealership part of it, is that this advertisement thing was very enlightening. It's kind of the same but different, that just recently I saw a news story about tow businesses that were operating. and who don't have license, and a lot of the consumers are really being robbed tremendously. And what my thought was, you know, when you have people who do it the right way in their license, they get penalized for mistakes they make. Rightly so. They're in business, but at the same time, one of the news stories was saying, you know, what do we do about these people who aren't licensed and they just keep getting away with it? And so in seeing that, it made me think that I do hope the Tennessee Attorney General would get involved to that criminal activity is still going on with advertisements, still leaves a lot of people vulnerable. And I do hope that Tennessee will consider doing that, because it's not fair. It's not fair to the dealer, it's not fair to the consumer.
We get a fair amount of complaints that involve towing, and we don't regulate it.
Right.
And it's a struggle for me always. I've been in contact, I have contacts at the Department of Safety, and I've shared some with them, but they have limited jurisdiction. I actually reached out to my old friend Bob Weaver and asked him about it, and he directed me specifically for Metro Nashville. They have a towing board, but it's unique, so it's a problem. You're right.
Yeah, so, but thank you, but especially to all of you that I've spoken with directly and worked with. It's been my privilege and an honor, so thank you very much.
Thank you. Anything else for today? Who wants to make the motion to adjourn?
Commissioner Norton, a motion to adjourn, please.
Any further discussion? All those in favor say aye. Aye. Opposed? Better not. Yeah. Well, hey, you got all that behind you now. You got most of it. You do. And you know, it'll get easier. It really will.